Yes. Any mentioning? No.
My Lordship, item 177, the special urgent, that person, that accused person is
177 will not reach, don't worry. Wait.
Lordship, special urgent, yesterday for the.
We'll see. 177 note को रखो. ठीक है. Okay. Any mentioning, Rishi?
Supplementary item 13, Lordship.
Huh?
Item 13 next week.
What is this matter?
Matter is the NI Act.
NI Act.
Lordship.
It is pending since 2014.
The matter conviction.
You are for petitioner.
Yes, Lordship.
Service is complete.
Lordship.
Service is complete on the complainant. That is opposite party number 2.
Maybe take up next week. Next week.
Service is complete or not? If service is not complete, complainant has to be there. What is the check amount?
13.
I know. What is the check amount? Service complete? Huh?
No.
4,10,000. Check amount 4,10,000. Compensation. The long trial court
Somebody is appearing.
appearing.
Yes, Nike.
Next week. No? Request of particular. Yes. No mentioning? Oh, sorry, there.
Sir, item 2.
Sir.
One after.
Yes, sir. Which item?
2, my lord.
Yes. Then I can take one.
Yes, my lord can.
Because I thought you may be.
No, but I'll wait.
Item 1. Yes. This
Case against, I have filed a discharge petition of the accused number 2, and it is refused.
your discharge application is turned down.
Not done.
Yes.
Well, against that,
When was it turned down?
Business case 1.
It was turned down in April. Charge has been framed.
no.
Yes. Posted for framing of charges. Okay. What are the grounds?
Well, your worship knows for a bribery, for a draft case, demand and acceptance section will be important in ingredient, rather the only ingredient where charge can be taken. Whether this basic ingredient is absent in one case. It is definitely here. The bribe money is recovered from them. It is admitted. But my case is like this. My boss is executive. I am the lowest rank, junior assistant.
Please use the mic so that.
Junior assistant come cashier. He is the highest official. And this bureaucracy, your lordship, whatever the I have to accept that. That is the money. That on that position, that is the position. Malad, there are FIR indicates executive engineer. He has given the executive engineer demand the money. Demand the money.
You have accepted them.
Yes. Executive engineer demanded the money. When money is given, he directed the bribe giver to go to the cashier and deposit the money there. And he deposited money. Cashier has not demanded the money. On the direction, they have told the same thing.
That is, sir, that is your defense.
No, not defense.
The only defense is, it is on the direction of the senior officer. The money was paid to me, I have accepted it.
My lord, that
and
is
accepted is at your end, demand is at the end of your senior.
Yes.
All these things has to be tasted in the trial. Yeah.
My
You
lord,
can't make-
your lordship
At the
see.
trial stage, at the framing of stage, charge stage,
No,
the
my
court can't,
whether a charge claiming friend, my lord, there are two things. FIR says so, and there are 164 statement. Petitioner, as well as the informant, as well as the whispering witness.
he might have said that, yes, it is demanded by, the bribe money was demanded by the engineer, superintendent.
He
And
says
I have
that
given it to the cashier. You are one of the accused. All these defenses has to be proved in trial. If you are discharged, then the senior officer also goes.
that portion, your lordship, that's why I made him party also to this case. But this is a fit case. Would admit and your lordship heard the matter and length. Heard the length. That is the only thing available. That is the 161, not 161.
Due respect, I am not with you, sir.
164 statement, my lord.
That's right. You are absolutely right. I take it as it is. I take it as it is. Still, it needs to be.
Then what is the material for me?
The prosecution may fail.
There is no other material,
The
man.
prosecution may fail to prove
The
case.
prosecution may fail. Then why shall I go
The fact that you have accepted the money,
well,
the presumption operates against.
my lord, your lordship knows that mere acceptance will not prove the guilt. Mere tented.
Why have you accepted then?
Because he's the boss. He told that.
Every boss will tell like that.
No, my lord, it is not every year. My lord, the fiduciary relation, your lordship should
That's
see.
right, but
Fiduciary relation between myself and
has the main accused said that I have instructed him to take?
Yes. No, he has not stated that also.
Then,
They say that. We have lordship.
this is the prosecution case. Demand is made by the engineer, accepted by the cashier.
My lord, your lordship.
And your case is, it is only on the instruction of the senior officer. I have done it.
Man.
If senior officer instruct you to do a illegal work, you can't do it and take immunity out of
it.
Yes,
my lord. That's it. How could I know that it's a bribe money or something? He says that, go on, give
that
it.
That is precisely that is the precise defense you have. That I had no clue that this is a tainted money. I had no clue that these are
they should.
I being a cashier, I casually accepted.
My lord,
that is your defense.
My lord, these two witnesses, 164 statement, they should say that, yeah, I have knowledge that this is a bribe. Your lordship knows.
You have a fantastic case, but at the end of the trial.
My lord, that might be. My lord, your lordship, try once. This is a very hard case because the timid man will be suffer.
Then I have to read the 164 statement and
everything. And only two things: 164 statement and FIR.
Am I permitted in a revisional jurisdiction to read the 164 statement?
My lord, everything? If there is no, there is the only material basing on which these things have happened. Based on 161 statement and FIR.
Without discharging you, what best could be done? You just suggest me so that I can try to do that.
Well, I have no objection if my learned friends provided with the leave to raise all those points you have tried.
No need to advise.
You are the many trial to examine all those things.
No, this is not a question.
Many trial is
your lordship, one of the decision of.
And the defense plea can be raised.
Fantastic defense, but what we can do, we can try to expedite it if you need.
Exactly.
So that at least you can come out of the problem.
My lord, your lordship, see, there are decisions of our own court also. Obviously, that is after trial, that is in trial. But the principle is decided by judgment.
With great respect, many trial is not permissible. And probative value of the materials on which my learned
there is no
cannot be gone into my lord at the stage of consideration of this application.
Judgment, where in the charge stage I can go into all these evidences and all.
This is not, this is a case where things are decided.
No, it is.
Decided in a trial, after trial.
That's what I'm saying. You have a fantastic defense. You
Madam-
will get out of this problem. So therefore, you just suggest
Ma-
me what best could be done so that you can come out of this problem by following due process of law.
To discharge me from the
No,
that's the
that's
best.
Then it's a mini trial.
That is the best thing.
Discharge may not be possible.
Sir, what?
Otherwise, I would have definitely.
Your Lordship, issue notice and we'll give you the distance.
But no entry models.
No, question of
Cannot be
that's it,
stored
right?
there.
And just issue notice. At your request, I must simply issue notice.
My Lord, then there is no meaning, they will frame the charge.
Can't be stayed.
They come again.
I can't stay it, but I give a short date next week or a week thereafter.
But then this within a week, nothing will happen, my
I
Lord.
think so.
Now, your Lordship give a short date.
If you want to argue the matter, no problem. I will give you time, but there is no question of stay in this kind of matter.
No, because there is other accused that he has to notice.
I'm
Yes.
issuing notice, right? I'm issuing notice.
You have noticed? And
I'll issue notice to the opposite parties also. You have you pleaded, yes.
yes,
Because the moment you are discharged, the main accused also goes.
Sale with you. Sale with you.
there is another offense.
Obviously, sale with
Anyway,
you.
I'm issuing notice let us, next week. And
Let's May
next week, which are give Monday, Tuesday, week.
date
Okay, item 2.
16. May Prime Lordship.
This will not be solved to him. That's why it is there. In the meantime, the case will.
No, I can't say. I'm so sorry. I can't say.
My Lord, your Lordship, can you call for the records
No,
By-
I have
by,
objected.
by that process?
That will stall the
But
process.
it is your petition, sir. You have.
Yeah,
to
my
satisfy.
petition is there.
You-
For any other documents,
File, in the counter, they may bring adequate material. I'll just see that those material. No problem. Yes, item 2.
Lordship, one copy a spare copy may be
Yeah,
given.
give it. You ask.
I'll give you a copy.
Spare copy.
Oh, take
Take-
it. I'll
take
give
in-
you.
give it. Yes. Thank you. Yes. 2.
I'm deeply obliged, my lord. My lord was pleased to accommodate me, and my lord had many things to tell about this matter, and that what I would have done if I was there. My lord, but
He has adequately argued.
yes, I want to indicate two things, my
Yes.
lord. A, my lord, here is a person who was in the CGS in Delhi, my lord. He has put in his entire savings in this. One, my lord. There are cases and cases, my lord. Two, my lord, he is a
My Lord, to register OP number, notice to OP number 2 by register.
Registered post. Yes. Registered post.
my lord, I would have been hardly even asking this to my lord. My lord, the co-equal bench, my lord, the Justice Rath, Miss Rath, my lord, had asked for two things, my lord.
Yes.
In the meantime, in one case, it seems my learned friend indicated I was asking him that they have filed a final form in one case. And the second case, my lord, admittedly, this gentleman is a scheduled caste. This should have ordinarily gone to the Scheduled Caste Act, my lord. And this case, the second case, my lord, has been referred to the, has gone for investigation to the special officer and has been transferred to the next court. The second case, my lord, the instructions were not there. It has come today, my lord. Friend told me-
Madam.
Yes.
On the earlier occasion on 7/7/2022, my lord.
Nay, what is the amount, Mr. Proceed?
Madam?
About 32 odd lakhs, my lord. I had given the money and instead of registering one, my lord, he offered me another. There is a RERA judgment in my favor already, my lord. And then, my lord, an offer was made here.
That the best, what best could be done according to me is,
My-
I will relegate you to go to the trial court for the purpose of modification of the bail condition.
Modification of, my lord,
The bail condition.
condition.
Because see, I saw the conditions are general conditions.
Yes, one,
General condition.
yes. And,
the
my lord,
monetary matter where you are particularly, you are at the fake end of your life, that you are 70-year-old.
yes,
At least you should get back your money.
Yes.
That should be protected.
Prosecuting him, sending him in jail will.
Is of no consequence, my lord.
consequence
I
for
am
you,
not
at
on
least.
that, my lord. I am, what has happened, my lord, there are two brothers. They are habitual with this, my lord.
And this gentleman is a 40-year-old man. Yes, Mr. Raghunath,
Or what happened?
some
See,
financial
let's-
recovery should be done.
May I please, my lord?
Permissible,
My lord.
yes.
Lordship, prior to this present case, with due respect to my learned senior, there was not a single case against me. I am not at all a habitual offender. There was not a single case. Even in my objection, when I brought.
You are lucky that you have been doing all these things, you got escape.
No, my lord, not a single case against me. I am fairly submitting, my lord. When I have filed my objection, in my objection, I have categorically stated that I don't have a single case against me as my criminal antecedent, which has been reflected by the petitioner in his application. Then subsequently, 2 cases have been foisted against me. If your lordship will peruse both the cases, one FIR and one complaint case, it clearly transpires from both the case records that both the cases have been fabricated against me. In one case, the petitioner has categorically mentioned as because he was threatened by me, he filed this application for cancellation of bail. And in another affair, he has categorically mentioned that as because I did not give him, I did not refund his money, then he came before this honorable court for realization of his money. In 2 different affairs, he has categorically mentioned 2 different things. And besides that, lordship, in his affidavit, he has also categorically mentioned that the RERA has directed the opposite party number 2 to me to refund the amount at the rate of 9.70 per annum within a period of 2 months. So when the RERA has already been.
Have you done it?
No, my lord.
Okay.
As per instruction, I have not paid. I have.
You pay it so that the entire case is put to rest.
And lordship, what happened? I have executed a sale deed in favor of the present petitioner, my lord. Though, as stated by my learned senior, there are 2 brothers. They have constituted a partnership firm, and they are the partners of that firm. When this sale deed did not materialize, another brother sold another plot to the present petitioner, my lord. So I am not going to the merit of the case, lordship.
What your case is in lieu of the amount you are supposed to refund him. In the same amount, another plot was registered in his brother's name.
Yes, my lord.
That
Yes,
is
my lord.
what-
There are 2 brothers who have constituted partnership firm. So these are the matter. These has to be decided at the time of trial. This is my submission. Definitely, my learned senior denied that. These are subject matter of trial. But so far as the criminal, even if this
Why
honorable
have
court.
you given it to the brother if the direction of the
No.
RERA court is refund the money to you, to him? Why have you given it to the brother?
No, my lord.
Yeah,
What he is
RERA.
stating is that his brother registered another sale deed in my favor. That is even worse. My lord, what he does, there
I
are
know,
2
yeah.
people. One, my lord, he has sold to me.
He was supposed to return you the money.
Yes,
Rather,
instead.
he says that my brother has given a plot to you.
Yes,
That's
that is what he's saying. That itself proves that he was, criminal intention is clear, my lord.
Lordship, we 2 brothers have constituted partnership firm.
No, then?
And even if the agreement which has been executed with the present petitioner clearly transpired that we have.
Show me the partnership deed.
Yes, my lord, I will file before this honorable court. I have not filed, it is with me, and even it's a part of the case record before the concerned court which has passed the bail order, lordship. In the bail application, probably the same has been filed, lordship. Even
According to me, I think the trial court should look into this matter and adequately change the bail condition. I'll just do that. That's all.
Yes, and my lord,
I'm not saying anything
Yes.
beyond that.
even recently, my lord.
Because see, you have to go into lot of document according
Yes.
to him also. Let the trial court go into it and take a call
Mm.
to alter the
Conditions.
bail conditions.
Mhm.
Because my view is once a bail is granted by the court below, the High Court should not cancel.
No, I bow down to I cannot,
discouraging
my lord,
the
I
court,
cannot at this side with my responsibility to the court, my lord, I cannot indicate that. I'm only indicating one thing very important. What was not reflected in my FIR, my lord, maybe by mistake, that I am a scheduled caste. If it was a scheduled caste, my lord, then the rigors of 37, all the other rigors will come in, my lord. And it cannot be before that court also, my lord. And
Yes.
it is for the
But
investigating.
in the FIR you have not written, so then.
Well,
how should we-
yes, and second FIR I've written. I think probably he wanted to, he was embarrassed to say that or whatever.
The petitioner is at liberty to approach.
Paiko Nagar.
Yes.
Lordship, may I submit one thing? If this is the situation, then the petitioner is at liberty to approach the learned court below under section 156(3) of further to monitor the investigation towards some offence or not if the offence is made out.
No, I am not
See,
on
what
that.
advice?
Not that stage,
Okay,
not-
okay.
not this
So these situations, so far, even the same was never raised at the time of the bail application, even the
You
learned.
tell me one thing, you tell me one thing, it appears to be the money dealing and property dealing. Will you settle the matter with him?
No, my lord, I have already.
And put an end to the entire thing. Why are you, see, ultimately you are into business and he is in his fake end of his life. Pay the money, put an end to it. File a
No,
482 and I will send it to mediation if you
No,
want.
my lord, we'll agree to withdrawing the FIR.
And put an end to it. Why are you suffering so many FIR?
No, it is not like that, lordship. First of all,
You are a young man. You can earn money. Why are you interested to get yourself, into this police case and all?
no, my lord, at all. Because
Will you think of settling the matter?
no, my lord, my brother he has already got back his property by virtue of the sale deed which has been executed by my brother, my lord.
Then.
RERA case, RERA judgment is staring at them.
Okay, right on. The present petition has been filed by the informant. You are a complainant.
Yes, my lord.
Informant seeking cancellation of a bail granted to the opposite party number 2 by the order dated 30th November 2021 by Lieutenant ASJ from Special Judge CBI 2 Bhubaneswar in BA number 2503 of 2021. Then Senior Counsel Mr. Das submits that there is a specific direction by the RERA authority to refund the money. However, instead of however, the opposite party has not made good the said amount. Lieutenant Counsel for the opposite party submits that in lieu of the said money, his brother, who claims to be a partner, has registered a sale deed in favor of the petitioner. And there are claims and counterclaims raised by both the parties before this court and before this court. The senior counsel appearing for the petitioner try to persuade this court for cancelling the bail granted by the court below against the opposite court below in favor of the opposite party number 2. I am not inclined to cancel the bail granted by cancel the concession of bail granted by the court below. However, I am of the view that the condition imposed by the court below needs to be varied in view of the claims and counterclaims raised by both the parties. In view thereof, I am giving liberty to the petitioner to move appropriate application before the court below for imposing additional conditions. While maintaining the bail order. Maintaining in such application is moved as petitioner, the trial court shall look into the matter and impose adequate condition on opposite party number 2. If such application the same shall be done as expediently possible, preferably within 15
I
days.
just want to, my lord, with one caveat, my lord has written that my learned friend accepts the fact that there is a RERA order. My lord has indicated.
I said that.
No, my lord has put it in my mouth that I have indicated.
no, lordship,
I'll see.
He himself stated.
it is no, lordship, it is from their affidavit, my lord. I read out from their affidavit, lordship.
I'll just see.
It is transferred from their affidavit itself, my lord.
I have written in lieu of that he has registered it. In lieu of that, he said.
All right. Deeply obliged, my lord.
Yes.
I'm so sorry for this matter, my lord. Because of the fact that I know him so very, very well. So, my lord, I am embarrassed also to indicate.
It's all right. the adequate condition, I see the ideal situation would be
If he
both
settles
of you
the
can sit together and settle
Settle
this. And file a 482 petition. and
Yes,
dismiss.
yes.
Even now I'm ready.
Yes,
If he
yes.
is agreeing, then I can send it to
Yes.
mediation. And I can record it also.
Yes, yes. If my learned friend agrees
I'll
on
record it. The trial court also, trial court shall also endeavor to see that the matter is settled between the parties, if the parties agree for a mediation. I've indicated that
Yes, my
better
lord.
would be go to mediation, pay the money and finish it up.
Yes,
And file a
Lordship.
482 petition, everything will be closed.
I try my best to convince, Lordship.
Something less, something more, he will also be agreeing to that.
Yes, yes, my lord, I try to convince me.
I have indicated that the trial court to begin with will have a mediation.
Lordship.
That's it.
Bless me.
Item 3, may I present VC Lordship?
Yes.
And file a restoration of order dated 17/5/2024 Lordship.
17?
17/5/2024.
Where is that order?
Order term. Lordship, Lordship rejecting the CRMC petition for non-prosecution of the order
Where is
dated.
that order? Show me that order first. Where is that?
Order भी देना था, हमको भी देना था।
অর্ডারটা দেইনি কিন্তু ওটা
Paragraph 2 রে
And that order will be presumed by the court. That this order was passed. Order, which one you want to recall?
Lordship, keep
You
it
have not
to
filed anything. Eh?
keep it to next week. I will file the order, Lordship.
Paragraph 2 रे लिख सकते हो?
Paragraph I mentioned, Lordship.
Where is that?
Paragraph
Up there, I, CRL,
Paragraph 2.
CRLM में. Some problem, the conducting counsel was not able to.
Wait,
The
you
court
have so, where is that order? It is there.
Order.
Order see, these are minimum thing. You are asking for recalling of the order. That order has to be there. Not there.
17/5/24.
17? So you have been consistently not appearing.
For that.
Why have you not appeared at the earlier date also?
Lordship, I am the on behalf of the Manoj Kumar Panigram, Lordship. Lordship, he is unable to attend the court, Lordship, because of the illness of the conducting counsel, Lordship.
See, earlier also you didn't appear. That's the reason I have dismissed. Okay, I restore it, but what is the matter? You tell me. Let us dispose it up right now.
Lordship, the main file is not with me, Lordship. So kindly restore and kindly take care of next week, Lordship.
No, I'm restoring it right now. So tell me
Yes, sir.
your merits.
But the main file have not.
Tomorrow
Not
come
with-
prepared. I'll restore it and hear you on merits. Okay, tomorrow.
Yes, yes, Lordship.
Tomorrow. Yes, sir. This is the petition.
So appeal against conviction, man.
Is a conviction.
Yes, ma'am.
What was his age at the time of filing it? He was 58
Yes, ma'am.
in the year 2006.
Yes.
So
58.
now,
2006.
count.
Yes. 66. 76, man.
Huh?
76.
So same order.
Yes.
None appears on behalf of the petitioner at the time of filing of the criminal appeal. Petitioner stated petitioner was 58 years old. Therefore, the SP so is directed to find out the well-being and whereabout of the petitioner is placed. Order the report. 18. None appears for the petitioner. Yes.
If the sole applicant has already died, and I have filed a IF number 127, substitution of the widow. They died on 14/11/19.
IA?
Date number 127. 127, 126 of 24.
127. It's not there. Item number 4, na?
Nothing is there.
5, yeah?
High.
Not there.
Cause list nothing.
Rather, the last application was filed by you
For
for
fixing-
early hearing of the.
Early hearing, yes, ma'am.
Yes.
Flag C.
Sorry. I early hearing, I have filed a IF for early hearing. and-
Are you sure that you are arguing the same matter?
Yes, Lordship.
What is the party's name?
Item 6 may misconcept. the
This is
item
item
6
number
I-
5.
Item number 5 is Purushottam Pani.
Yes, Lordship.
You are arguing,
I-
Purushottam
I-
Pani has expired.
No, no.
Why?
Lordship, item 6.
She was mentioning about item 6 instead of item 5.
किसी को भी मरवा देते यार. चलो early hearing allowed. Argue.
Yes.
Argue. What is this matter?
Lordship, fix a date.
Date
Today
is today only. You sought early hearing, it is there tomorrow. You want early hearing, you don't want to argue. What is this? Tomorrow,
Fix a date.
Day after.
next week, next
day after.
week, Day after.
You are seeking early
Friday,
hearing.
Friday. Friday.
Friday. Okay. Friday. Early hearing. Early hearing allowed. Leave the matter on Friday for hearing.
But can it be on next week, my lord? So,
Next week, Mr. Ijvi is problem next week. You tell me the date.
Right.
You tell me
Friday.
because you have to be ready now.
no, it's 18th.
18th. 18th.
18th వచ్చి. Acha.
18th lot of matters.
And
18th, 15th leave.
16th. then,
16th. 16th.
Yes.
Early hearing application allowed. Leave the matter for hearing. Get ready and
Yes,
come.
yes.
Yes. 6,
The
what
item
happened?
6. Item 6, Lordship, the sole applicant has died.
There are two appeal. One Madan Mohan Mahapatra and another is
Uh,
Jagannath Naik.
Jagannath Naik has already.
Jagannath Naik has died, huh? And
I am-
you moved application. There is delay. How much delay?
Date of date 14/11/2019.
How much delay?
5 years. 5 years. I filed it 16/1/2020.
Do you have anything on merits?
Made it there.
If you don't have anything on merits, this application on delay ground will dismiss so that.
Yes.
Yes, made it.
Seriously,
Misappropriation case.
It's in that,
Video.
my lordship, in that case, this matter may be tagged in the weekly list. Your lordship may hear the matter if your lordship feels that there is some merit.
weekly look at your application allowed, huh? The application under section 394 moved by the wife of the wife of
Case of
the
widow.
sole deceased appellant to continue the appeal is allowed allowed 127. The application for condemnation of delay in moving the application, moving application of the 394 KRPC is also allowed. In view of the cause shown in the application, Mr. Ijvi opposed the claim. However, in view of the sufficient cause shown in the application, the same is leave the matter.
Item 7.
May I please, your lordship?
Yes, madam.
My lord, my senior is suffering cold and fever, so kindly give another
In the
day.
summer, how can you suffer in cold? What is this matter, you tell me? Yes,
No,
this is against conviction.
Yes, my lords.
Conviction.
Section 7, my lords.
Weekly list.
Yeah.
I'm including it in the weekly list. Get ready. 2010 matter.
Yes, my lord.
Yes.
Item 8.
Oblige, my lord.
Eight, confiscation.
Also, reproduction.
Madam, this is the confiscation appeal against the final order.
The stay is operating.
Yes, madam. And they are not present, madam.
Right on. This is an appeal arising out of order of confiscation, final order of confiscation dated 20th September 2014 in CC case number 4 of 2012. Interim order of stay of operation of the impugn order is operating since 30th November 2014. None appears for the petitioner. None appears for the petitioner. In the interest of justice, leave the matter on Friday. Nobody comes, I'll dismiss.
That should be SR pointed out the defect.
What is this matter, you tell me first?
Matter is the confiscation proceeding. The confiscation proceeding against the appeal. That's it.
Yes.
Interim order.
This is not against the final order.
Final, the interim application.
What is this?
2016, they have not removed the defect.
Then you argue all these things before the authority. Confiscation authority. This is an appeal against interim order dated. Nothing is filed. Interim order dated 23/9/2016. 16. The appeal is pending since 2016. The petitioner has not removed the defect. Since it is against the interim order and the confiscation proceeding is still on. Confiscation proceeding is on.
Going on.
Going on, the petitioner is given liberty to raise all these points before the confiscation authority. With this observation, the petitioner is dismissed. Yes.
Item 10. Item 5.
Then he is also, what is it?
13-1 conviction, your lordship. 13-1 and 13-2 convicted. I am before your lordship.
Ready? Ready to argue?
I may have to take instruction. Last night, generally, I asked you.
Then I'll put it in the weekly list. Get ready. Anytime. In
After 2 weeks.
It will come after 2 weeks. Yes. Weekly list.
Interim order.
Interim order is there. It will continue. I am not saying anything. I am not passing any order. It will go to weekly. If they did there, I am not passing today any order.
Automatically it will go.
Automatically. Yes.
Item 11.
My lord, sole appellant diet there was days as the petitioner advert received telephone the information from
Sorry,
the
I didn't follow you.
sole
Yes. Yes.
sole appellant diet
When?
there was days
In first item, there are 2 items, 3 items.
11.
Dr. Ananta Charana Esra.
Sudama.
Huh?
No, wrong. Anantarana Bisra.
Sudama Hemram.
No, Anantacharana Besra is dead.
No, she is not sure about.
11 item.
ସେଇଟା ପରା ସେ ମରିଯାଇଛନ୍ତି ସେ ଜଣେ ଆକ୍ୟୁଜ ମରିଛନ୍ତି he has to change the cost title file
नहीं
amended
application file करें तो application करना तो why should I just
हाँ करना
wait
मैडम
के वे मैंने date को और 289 आपको 2018 criminal appeal
16/6/2021 ରେ
it is stated, has he moved application?
ଆଉ ଅଦର ହଉଛନ୍ତି କୋ ଆକ୍ୟୁଜ ସେମାନଙ୍କର ସମସ୍ତ ଆପିଲାଣ୍ଟ 3 ଜଣ ଆକା କନଭିକ୍ଟ
Is there any application?
ହଁ ନାଇଁ ଆପ୍ଲିକେସନ ଥିଲା
Fine.
application ଥିଲା I have obtained instruction that his dead and on 16/6/2021 so he has to file an amended cause title
394 is allowed or what?
na
Where is that application? Have you moved any application under 394 to continue the appeal?
IA number your lordship kindly say IA number 952/2021
Okay. It is not allowed so far.
not allowed
Huh?
not allowed
The application, the sole appellant in the present case has expired. Therefore, the wife of the deceased appellant has moved an application seeking to continue, seeking leave of the court to continue for the appeal on behalf of the deceased appellant. IA number 952. For the reasons stated in the application, the same is allowed.
sorry my lord your lordship kindly see the order dated 22/3/2022 recently file has been entrusted to me 22/3/2022 perhaps there is an order for allowing substitution
The application is allowed already.
my lord Suman
In view of the
Order
fact
dated.
that the petitioner has not complied with the orders.
consolidated cause title file kariye
Petitioner has not, the appellant has not filed the consolidated cause title as yet. She may file the consolidated cause title by tomorrow. Release the matter for hearing in the weekly.
weekly list has to issue
What is it? Sudama Hembram also died.
ତାପରେ ଫାଇଲ କରିନାହାନ୍ତି ଆପ୍ଲିକେସନ ଦେଇନା ସେ ମେମୋ ଦେଇଥିଲେ କଣ
I received Sudama Hembram, a criminal appeal number 342 of
ସେ ଫାଇଲ କରିନାହାନ୍ତି ଆପ୍ଲିକେସନ
1 minute. The counsel for the appellant has filed a memo inter alia stating that the sole appellant in the present case has died on 13/5/2023. The memo is taken on record in view of the fact that the sole appellant has expired. In the meantime, the appeal stands awaiting.
May I please your lordship that
Yes.
item 11 my lord sub
ନାଇଁ
item
ସେଥିରେ ସେଥିରେ 3 ଜଣ ଆପେଲାଣ୍ଟ ଅଛନ୍ତି ଗୋଟେ କେସରେ
Separate appeal by
ହଁ ସେ 3 ଜଣ ଗୋଟେ କେସରେ 3 ଜଣ ଅଛି
342 appeal is awaited in view of the fact that he has died. Yes.
my lord sub
The other 2 appeal
Nah.
will be heard.
my lord item 11 sub item 2 the name of the Mr. Learned Counsel Senior Counsel Samir Kumar Mishra and their associates name may kindly be deleted. Consent is taken by the appellant.
Samir Mishra.
Aye.
Name may be deleted.
Yes, my lord.
Next item number 2. On behalf of Mr. Samir Kumar Mishra, Senior Counsel, it is stated that no more appeal in this matter, his name will be deleted. Yes, this matter in the weekly list. Yes. Next. Why is this criminal?
Please balance.
Yes.
Take your lordship.
How this matter has come up?
Specific answer by your lordship.
Because, yes, yes.
Just ascend this matter.
Justice it had gone for Justice Mahapatra, probably he was concerned. Lordship, may kindly have a glance at the order dated 12/9/2022 by your lordship's coordinate bench earlier.
12/9?
12/9/2022.
I'll take 2 minutes, you just place that order. Lordship got that? 12/9. 12/9/2022.
2022, huh? 12. 12, fine.
Manas.
Yes.
Manas. Paragraph
3.
2. Yes, 3. Mr. So-and-so, learned senior counsel for the petitioner submitted that the petitioner does not have any role to play, rather purchased the vehicle, being refinanced, but he has been entangled in the case by the local police later to the lodging of the FIR, pursuant to which Airfield PS case number so-and-so was registered under section 467, 468, 471, 420, read with 34 of the IPC. It's further submitted that if at all any mischief has been committed, it was apparently by the seller, namely Devi Prasanna Padhi, who sold the vehicle in favor of Mrs. Suchismita Das. And therefore, no case is made out against the petitioner, who in fact, in the meantime, cleared the dues which was payable to the Tata Finance. And in that connection, refers to a series of documents under Annexure 4. Now, it is further submitted by Mr. So-and-so that all the relevant documents with regard to the refinance and payment of dues were submitted before the IO. But keeping the same aside, the charge sheet was filed. At this juncture, Mr. Mahapatra submits that instead of the informant may be summoned, the court also agrees that the Tata Finance, being a necessary party, should be noticed so as to have its response in regard to the nature of the involvement vis-a-vis the petitioner. Now, what has happened is, one Devi Prasanna Padhi had sold a vehicle to one Suchismita Das. So, Suchismita Das purchased the vehicle from Devi Prasanna Padhi. After purchasing the vehicle from Devi Prasanna Padhi, when they went, after paying 8 lakhs or something, some full amount, when they went to transfer it, they found that the vehicle already has some other loan by some ICICI bank which was not paid by Devi Prasanna Padhi. Now they went back to Devi Prasanna Padhi and said, we are unable to transfer, you take back the papers, take back the vehicle and give me my money.
Suchismita.
Suchismita. Entire transaction between Suchismita and Devi Prasanna. So Devi Prasanna said, all right, give me the vehicle, give me the papers, I will give you the money. He took back the vehicle, took back the papers, did not give back the money to Suchismita. Devi Prasanna sold me transferred the vehicle to me.
You are the second purchaser.
I am the second purchaser. I did not take it directly from Devi Prasanna. I took it through a refinance by Tata Finance. Tata Finance made a search at the RTO's office. Tata Finance got a search report that there is no encumbrance on the vehicle. No loan, no nothing outstanding on the vehicle. I've annexed all those documents in my OA. I'm sorry, for 482 application. Now, then this gentleman comes to me. No, Suchismita's husband, who is the informant. Now, he's in fact...
He is agreed because his money,
whatever
he has paid, is not returned to him.
By Devi Prasanna, by Devi Prasanna. I took it cleanly from Tata Finance in a refinance. I have paid off the entire loan of Tata Finance. No due certificates I have.
Don't have any privy.
I have nothing, no privy, nothing. And so therefore, my lords, I was available in the local, my lords. I am an established businessman and my lords, I execute contracts all over the country. These these cable contracts, these high power cables and all that. So I have my office in Shahid Nagar. Police inspector knew me, everybody. My lords, I'm an established businessman in Bhubaneswar. Running into my turnover runs into crores. Now I have paid back the entire loan. The charge sheet was filed against me. The inspector came, took all the documents from me. He said, all right, sir, I will take care of it. I will. So
which vehicle is it?
I'm sorry, Innova, some Innova vehicle. Innova vehicle. So he said, sir, I will take care of it. Don't worry, sir. After a year or something, suddenly a court summons comes that I am an absconder, charge sheet has been filed. Now, this court has been pleased to enlarge me on bail in another application, my lords. Now I have come for quashing, my lord. Unnecessarily I am being harassed. So therefore, my lords, when all these documents were placed before your lordship took cognizance of that.
What is her claim? Her claim is only that 8 lakh rupees which you have paid.
That is that from Devi Prasanna.
No, that is the only
That is the
FIR.
only thing. FIR. That
What
is
Devi
the
Prasanna is saying?
Devi Prasanna is an absconder where he has gone, my lords. We are not. I don't know.
He is your good friend.
My lords.
He is your good friend.
He has in fact, my lords, forged my
Just
signature.
him out and pay the money, finish it.
No,
everything.
but he has forged my signature. I am no way connected with any transaction. Your lordship.
Your signature means what? How? You have no preview with the.
No. I have nothing.
Which document he has forged?
Police says he has shown some guarantee documents where my signature is there. It's not my signature.
Guarantee where? Where have you furnished the guarantee?
Some loan.
No, he has executed.
Lordship may kindly see. Lordship may.
He has executed the documents with the opposite party number 3, Tata Finance, my lord.
Kindly.
And availed the loan for refinancing the vehicle. This informant has no grievance at all.
Against me, he has no grievance.
Obviously, that's a completely separate
Transaction.
Yes, but charge sheet has been filed against him.
Kindly, lordship, look at lordship. Kindly.
You are the informant.
No, he is Tata Finance.
I am the Tata Finance. I am talking
Informant.
Where is the informant?
Informant has been noticed. Informant thrice he was noticed. Informant never turned up. It transpires that the informant is also not
interested to proceed.
No, not probably not alive or something. Not
Husband of Smita.
Again?
Husband of Smita.
Husband of Smita. Dekhe, page 20 ta dekhe dekhi diyantu. Annexure 3 ta. Kindly come to Annexure 3.
Yes.
The third line. The seller of the vehicle as per our records is Suchismita Das. Presently, the vehicle is under hypothecation of Tata Capital. Further, at the time of financing at our end, this was in reply to my lord's.
How come seller of the vehicle is Suchismita?
Suchismita sold, my lords. Suchismita was the owner.
You said Suchismita has purchased it and refunded it.
Yes, Suchismita has purchased from that person.
No, that transaction.
You have purchased it according to you from Devi Prasad.
No, Devi Prasad.
Tata Finance record shows that it is Suchismita from whom you have purchased.
No, Tata Finance.
This is the document you are showing, Tata.
Yes, Tata Finance, my lords. Further, at the time of financing of the.
Who is your seller? From whom you have purchased?
The vehicle was free.
No.
Vehicle stood in the name of Suchismita. Yes. She sold it. Yes. Suchismita sold it.
The story which you have narrated.
No, I'm sorry. I'm sorry. Devi Prasanna was the mediator. I'm sorry. Devi Prasanna was the mediator.
That's there.
Annexure, that is that annexure.
Say that there is no privy with the.
No. I'm sorry. Annexure 4. See this page 21. Suchismita transferred the vehicle to me.
Yes. Then you have a direct privy with Suchismita.
Suchismita sold it to me.
Yes.
And I purchased it on refinance.
That's a different story. But
she might.
Suchismita raising a grievance against you, maybe looked into. Not that you don't have a privy at all. The story which you put forth.
Suchismita is not raising any dispute here.
Husband of Suchismita.
Husband of Suchismita.
Obviously on her behalf.
Husband of
Suchismita. Because money.
Husband of
Suchismita. Money.
Yes.
Purchased in the name of wife. Purchased in the name of wife.
But my lord, allegation in the FIR is different, my lord. Kind of page 12, my lord. He has stated.
My money, my lord, I have not Suchismita, how vehicles are refinanced. Since there was a finance by Tata Finance refinanced the vehicle to me. Refinance vehicles are normally purchased from the previous owner through the finance company.
Set up the earlier loan and
yes. So therefore, I have paid back the entire loan to Tata Finance. There's a no due certificate. Your lordship will see page 28, 27 and 28. I don't have to pay anything to Suchismita. Page 27, 28. Entire loan, my lords, has been paid off to Tata Finance. And then, my lord, the next page, your lordship will see termination of contract with Tata Finance. I am free.
What might have happened is the vehicle is in the name of Sujismita. This broker, that Devi Prasad, has sold it to you. You avail the loan and purchase it. No
My
problem.
lords, that is exactly how the
But since
transaction.
the vehicle was in his name, in her name, money has to go to him. That money is not paid to him. Therefore, he filed the complaint.
That is not his case.
That is the whole story
No,
terminating from what you are
the
saying.
FIR is this.
Let us see the FIR.
FIR,
Page 12, my lord, last part.
FIR is page 12,
So yes. Yes. Read it. What is it?
page 11. 11 report. What else? English translation. Translate. हाँ देखिए सिचुएशन 161 टा देखिए 161 सिचुएशन टा को दिना there's a translated copy, my lord.
Devi Prasanna party
Expected.
absconding.
Absconded. Both were absconded, but my senior has stated that he.
I have not absconded. I am available.
Charge sheet was submitted as absconded.
That was because of the.
And you were sure that nothing will happen, so you remain like that. But
I gave them my documents.
Main guy is Devi Prasad party.
I gave the
Main
documents.
guy is that Devi Prasad
Devi Prasad.
party. He is a broker, it seems.
He has
गाड़ी लेके उसको बेचना है, इसको गाड़ी लेके उसको बेचना है.
he has sold that property to the lady.
Why should I, my lords, bother about a 7-8 lakhs car when I myself, my lords?
This Prasanna party might have appropriated the entire thing.
Devi can't got
Devi
you.
Prasad.
The copy of the FIR and reading translated copy. I, Sri Ashok Kumar Das, aged about 42 years, son of so and so Buddheshwari colony, hereby informed that Sri Devi Prasad Padi, son of Pitambar Padi, had sold the vehicle. That is a red colored Innova bearing.
The vehicle is in whose name now?
In the name of the petitioner, Sushant Kumar Pujari.
When the vehicle was in the name of Suchismita, how it has been transferred?
On submission of the document by the Suchismita. So
Must
it
be
is
there-
important to read the statement of the Suchismita, whether this
FIR ta tikke padi
is
da.
the investigation.
And she says that my it was.
It is his husband saying. But
Tikke again, tikke,
owner of the
tikke,
vehicle has not.
tikke FIR ta again, tikke mu padi doche FIR ta.
RTO registration ମଧ୍ୟ ହୋଇଯାଇଥିଲା କିନ୍ତୁ ମୁଁ
ତୁମେ
ଜାଣିବାକୁ ପାଇଲି ଯେ ଉକ୍ତ ଗାଡି ଫଳରେ ICICI ବ୍ୟାଙ୍କ ଭୁବନେଶ୍ୱରରେ 8 ଲକ୍ଷ ଟଙ୍କା.
But later I came to know that there is an outstanding loan of 8,33,000 from ICICI Bank on the same vehicle. But Devi Prasanna Padi registered the vehicle in name of my wife by placing forged NOC in the RTO. I said Devi Prasanna to Devi Prasanna Padi, why did you commit fraud on me? I am going to lodge an FIR against you. He said that if I inform the police station about such fraudulent matter, there will be more difficulty and the bank will take over the vehicle and I as well as my family will be defamed. After that, Devi Prasanna Padi and his father, Pitambar Padi, invited me to their home and said to return all the money within 10 days and cancel the RTO registration certificate. On 12/3/2009, I returned the vehicle bearing registration number so and so and original RC book to Devi Prasanna Padi in the presence of his father. However, when said Devi Prasanna Padi to return my money, he did not give me. After 10 days, when I contacted his father, Pitambar Padi.
What about the ICICI Bank loan? It still stands in the name of the vehicle?
We have no idea about that. Must be standing.
You are supposed to know, sir. You are the bank. You are now with him.
This
You
is
have
Tata
given a
Finance.
clearance. You
No,
are a bank.
At the time
You
of,
don't, you say that there is no encumbrances, there is
they
no
have not
money.
produced any document, my lord.
It is you.
We
you-
have verified. We have
See.
verified from the RTO. that what is the status of the vehicle?
Now you are
And
suppo-
it says that it stands in the name of the Suchishmita Mantri. We received the communication from the RTO.
But the allegation
But
is,
there is no
there is
such-
loan of 8 lakh rupees lying
has
in
not
the
been-
ICICI bank.
that-
You being the bank, a private bank, you are supposed to have due diligence.
That has not brought to our knowledge by the RTO. RTO gave a report that it stands in the name of Suchishmita Mantri. On the basis
You
of
want
that
to save
report,
today you want to save your money because you
No, no.
have financed him. That's your
we
idea.
finance him on the basis of the report of the RTO, and RTO has not disclosed.
That is what is false. That is the allegation.
Yes.
But prior to that, whether the informant is speaking truth or his wife, that 161 of the wife has to be seen, the owner.
Not
Unless your lordship may kindly see, if he is making the allegation, all these things, he should have brought to the notice of the RTO immediately. He has not done anything before the RTO.
No. He has been the
Who
notice of
was
the.
the original purchaser of the vehicle?
My lord, Paddy, my lord.
Paddy.
Original owner.
Paddy.
He had taken loan from ICICI Bank
Paddy.
and got the vehicle registered in his name. Then he wanted to sell that to Suchishmita. He sold it. And
Managed to transfer it.
allegation is in the RTO he manipulated, no due certificate was given, and it was registered in the name of Suchishmita.
Thereafter, it was refinanced.
Thereafter,
This,
you got it
petitioner.
refinanced, purchased it.
No, we have not purchased.
He
He
purchased
purchased by
the
taking
refinance
loan.
of
Your interest is to secure your
my lord, our money, my lord.
money.
So when we finance the vehicle, RTO, the registration certificate does not discloses that it was hypothecated to ICICI Bank. So there was no occasion on our part to have any doubt on the
Hypothecation may be there, but
the
no
hypothecation has been lifted on the basis of the NOC submitted by the earlier owner.
show me the original
So that can
RC.
be-
Show me
that-
the original RC.
But that can be produced by the, my lord,
Show me the original RC.
prosecution, my lord.
Sir, show me the original RC. Do you have seized that original RC? The original RC will show everything.
Original RC, NOC, if at all given
Or
by the
the,
ICICI.
see, or the original RC
Madam,
would
he has
have the endorsement.
My lord, hypothecation,
Hypothecation
Yes,
to
ma'am.
ICICI Bank or hypothecation to X or
Ah.
hypothecation to Y.
my lord.
Where is that document?
The document is not available in.
You get that document.
My connection is
But
only
he
that
has
I
filed
took it on.
another RC, my lord, that page
See,
21.
those RCs are manipulated.
Against the present
RC.
petition.
First RC where the vehicle was originally purchased, that in that RC there would be endorsement that it is hypothecated to ICICI Bank.
That is the
If the money is paid, then clearance is given. Thereafter, that endorsement would is removed.
Correct.
And then only it can be transferred to Suchishmita.
Yes.
Thereafter, from Suchishmita, they have purchased. Forget about Devi. I am not interested in Devi. Now, from Suchishmita, they have purchased. I just want to know the bank which has financed to this gentleman, whether due diligence has been done by them or not. Because today, why I am looking into that is because this bank who is financed this gentleman is trying to support him. Because their interest is only their money. They are not interested in
No, no,
them or not interested in because they finance it. They want to secure their money.
Trying to support. I purchased on a refinance from the finance company.
They are interested in securing their
So
money.
I am not.
So therefore, they are with you.
I am not aware of what happened in the past. So I don't have any knowledge.
Today, in so far as
Today
this,
I have paid back the entire loan.
sir, today in this as far as this proceeding is concerned,
No.
he is a stranger. He is completely a stranger. I can't take cognizance of his presence also. Because neither he is an accused, nor a witness, nothing.
Man, but there is a finding by the.
Today, I am surprised why he is not even a party.
No, I have been added.
He has been added.
Who has added you?
My
Party?
lord, this
Court has added. Court has added in my party.
Where is that?
That is the order dated 12.
opposite party. number
Anyway,
three,
but
my
you
lord.
have even if you are added, you are a stranger to this proceeding.
My lord.
Complete stranger. to this.
That is the my lord's order of the court.
It was not necessary, of course. When in a criminal
That was
proceeding, a
necessary.
stranger should be in.
Once the court comes, my lord, once the court came to a, my lord's conclusion that I have nothing to do with this fraud.
Sir, in
In
a
fact,
482 proceeding, why should we conduct
Understand,
a
I-
inquiry who is given, who is not given, make him a party, make the, all these things are not required. At this stage, all these things are required.
My lord-
Whether
my lord,
your role as it is accepted by the prosecution, whether any case is made out or not, that is the only test.
that's the only.
That's the only test.
Yes.
On that basis, I want to see the original RC. If the original RC says that it was hypothecated to ICICI Bank, then the end of the matter. You are out.
My lord.
You are out.
Let them produce it. my lord.
You get the original.
Right. But my allegation is that in the affair, that the present petition, Devi Prasanna has refinanced the present petition. But in the.
No. He has
Yes.
got refined from institutional
My lord, Devi
refinance.
Devi Prasanna might have sold.
He may say whatever, but institutional refinance.
Refinance
That's
was
the
made by
reason.
the Tata.
That's the reason
Institutional.
the court has implemented them.
That's the reason.
Institutional. He may say whatever.
And but the document in Annex 3 is told that
Devi Prasanna
that
might
lady
have
has sold the
list.
present
The
petition.
problem is it is a proxy FIR, not by her, not by the husband.
Devi Prasanna might have been a catalyst in the process, committing the fraud.
Main accused is the real
Devi.
fraud is Devi.
Yes, madam. Entire
Because
case record
you
is
are not
also-
able to arrest him.
Yeah.
They are.
I was available. I gave all these things to the inspector.
Why are you not apprehending him?
And then I forgot about it. I literally forgot about this whole thing.
Why are you not apprehending him?
Suddenly this surfaces like a thorn.
My lord, he is absconding since 2014 perhaps. Charge sheet was submitted 2014. He is absconding since then.
Have you made him an party?
Suddenly the FIR surfaces like a sore thumb, my lords. And I'm embarrassed, no ends, court kuja, surrender what? I have paid back the loan and my lords, for a small Innova vehicle, why should buy the hell should I bother? I'm executing contracts of my lord, my turnover is 100 crores and what I'm.
My lord, that
I'm not-
original RC, it was perhaps kept in the.
Unless there is no Gujarat ki city court ko jai.
He is absconding. So police might not have.
The police has to do the good job. Just see. Try and.
Because charge sheet
Yeah,
submitted.
Time
And
लगेगा,
he was absconding.
we actually lucky to forget it. This is not the way.
And from the
investigation is
RTO
done.
office,
This
if
is
the
not-
prosecution got that certificate from the RTO office, but the RTO office, it was manipulated. So it is also not available, original RC is not also available in the. RTO
or
office.
How have you made him as accused?
मुझे केमते accuse करिए? This document is with the police,
It was
available.
refinanced by that David Persona and sell to the present petition.
Refinancing now it has come to the light that refinancing is done
Tata
by
Finance.
Tata. You believe the FIR, believe the investigation. You have investigated,
Right.
you found that Tata has done. Still you are making him an accused.
अब से document ताको बगैर अच्छी है, inspector बगैर दिया है थला. से
The
देखिए कि कौन-
original RC was not before the.
That's right, but
Tata Finance.
if the complainant says that it is financed by Devi Prasad main accused, where in the investigation you found that no, it is the Tata Finance.
Investigation is Tata Finance.
Then why have you made him an accused? He got finance from Tata and got the vehicle. Merely because you are not able to cut hold of for the main accused, you can't bring anyone and file the charge sheet. That's perhaps the reason.
Tata Finance is also mentioned in the FIR. FIR भी लिखी
I
चंद.
think that you get that man. What is that person? Party. Devi Prasad.
Devi Prasad.
Send it back for the investigation. Or your lordship can send it back for the investigation again.
I want to finish it up here.
Again.
The entire case.
Great.
Unnecessary.
Again.
They will cut hold of that Devi and get 8 lakh rupees and everything is closed. That's the whole idea.
Again.
I'm giving next week. Tell the police that bring him.
That they
can do it. The address is there and everything he has already supplied. He's his good friend. That Devi Prasad.
ଆମ ପାଖରେ ନାହିଁ ମୋ ପାଖରେ informant ଦେଇଛି Devi Prasanna's address.
Tell the police.
The informant has given the address of Devi Prasanna and his father. ବାପାଙ୍କ ଘର ଯାଇଥିଲେ informant in the FIR states that she has visited the.
File a response. Have you filed response?
Who?
Have you filed response to this petition?
No matter.
You file a response? And otherwise I'll quash him. It is a loss for you. Come over. Then counsel for the opposite party is trying to file the status report. The status report, file reply to the petition and also file appropriate document to support the case. Let me do so within a week. Leave the matter. You will tell the file a response.
This matter will be taken up.
Hearing of date
16.
16. That is, it is made clear that no further examination shall be taken. Instruct the police to catch this.
That's deliberations.
My lord, may indicate opposite party number 1. Other opposite parties are there.
Yes.
The interim protection may continue.
Interim order to continue.
Great. Urgent copy.
14.
13. What is it? Who has mentioned?
I am for the opposite party.
That 138 matter.
My lord.
What do you say?
In this case, the opposite party, the complainant on the court below, trial court convicted the petitioner. Appeal also confirmed. 8 lakhs, my lord, check amount. That may fix so that.
No.
Not
He
a
mentioned it. That's the whole difficulty. Call.
Urgent for this, he's the, I would rate.
There is no point. She has to pay.
Yes.
In a 138 case, in the revision.
Case of the year 2012.
2012. How many years you'll keep on caller?
Original case 2008.
Then either she has to pay or I'll send it to mediation installmentally or something she can pay.
Mediation में acted लोक अदालत को जाई थला आसिलेनी.
तो dismiss कर दो कौन? कब दी? 11. In the morning, the AKC mentioned the matter and she sought for an adjournment. When the matter was, accordingly the matter was adjourned to 11. At this stage, Mr. Naik appears for the opposite party and submits that the original complaint was filed in the year 130, filed under section 138 NIS in the year 2008. The petitioner has already been convicted by both the courts below, and the matter is pending before this court since 2012. In view of this, it is made clear that this matter shall be heard on the urgent date, and the petitioner shall not be accommodated henceforth. Very clear. Either you pay or yes.
Item 14.
14 I pay for short adjournment only.
2012 matter.
Short adjournment. I am concerned.
No, it's all right. What is this matter? But let us understand.
The conviction under section 325. 325 IPC. Even though the learned court bill on the same matter acquitted on the matter of on other of 341 294. Only
Sentence?
Sentence is 2 years.
2 years.
And 1,000.
Maintained by appellate court also.
Maintained by appellate court.
Appellate court. Undergone?
Undergone that I have to take instance. Only
undergone you can find it from the record.
LCR, but that
this is the incident happened on in which
2002.
Year? Just check it up the undergone period, and if substantially if you have undergone, we will consider it.
That's it.
So
I'll verify from the LCR.
Let it be there in the board.
From today.
No, I'll put it next week. Take it next week. Next week, may video. And the meanwhile, the learned counsel for the petitioner submits that he would verify from the record the period undergone by the petitioner, leaves the matter.
Hon'Ble.
If the substantial period is already undergone.
That's it,
we'll-
for that. The
Yes.
imprimatur is there. Hon'Ble.
Yes.
Item 15.
Yes, sir.
Yes, but I am for the petitioner. All these three cases, your lordship.
3 cases you have.
Yes, ma'am. 130 enact conviction materials.
Conviction.
Yes, ma'am. I today taken consent from my client, your lordship is ready to settle me. And I pray let this matter may can be placed before the mediation.
Mediation
So
के
the
अंदर
mediation report will came.
No, you tell me what are the check amount first.
First one is 13, check amount 12 lakh.
12 lakh.
And
Second,
awarded in lordship 13 lakh 92,000.
second one.
First one.
First one. Second one.
Second one, lordship.
check amount is 320 lakhs. 3 lakhs 20.
No. 3 lakh 20, it is in 3 lakh 77,000.
In all the 3 cases, what is the total check amount?
The total check amount will issue
8 lakhs 20,000.
Huh?
18 lakhs 20,000.
18 lakhs 20,000.
yes, ma'am.
But yeah, there
How
will
much
be
you are ready to pay? Tell me.
Your lordship, difficulty is there, your lordship. My client supposed to come today because his mother on sudden illness, he had been to Bombay, your lordship. He's taken time to me. This Saturday he will come, your lordship, and will give the entire picture how much. I have stated in instruction to him that the check amount is required to be made payment. Even if the compensation amount may be exonerated by the court, but so far
I am
check
talking about only check amount.
amount. Lordship.
He should also be
I have
happy
given
with that.
solution, and he'll come this week on Saturday, your lordship. Thereafter, give the clear picture.
What is the compensation?
The
My lord,
compensation
in
one
first
percent-
case 1,92,000.
92,000.
Mhm.
And second case is 77,000. Third case 54,000. All this compensation.
Some amount be reduced.
What
I
some amount?
concede.
All the amount will be reduced. Check amount to take and
I respect one thing is my submission.
I leave it to my lord.
Yes. There is a communication gap between the complainant and so far the accused is concerned. One date may mediation may can be next week, your lordship. So both will sit together and take a decision so that the money will be paid, your lordship.
I'll assure you, you come with
Draft.
At least 10 lakhs draft, and I'll give it and send it to mediation. For rest amount, we'll see.
The next week as well. Let it be next week.
18 lakhs is the amount, okay? You come with 10 lakh draft, give him, thereafter I'll send it to mediation.
I will propose
And the
the
remaining amount.
yes,
you
yes,
can
sir.
decide and,
Your lordship, this is, I also propose to my client to that effect that order amendment pass, your lordship. It
I
may
will not pass any.
yes, ma'am.
I will not
Next
pass
week
any.
I will
I'm
also
making a
so that
proposition, come with 10 lakh draft, let us give it to him, and all the 3 matter will send to mediation.
mediation so
And
that
the
it will be
remaining
paid.
amount you can negotiate and
Yes, yes, yes,
take
correct,
it
correct, your lordship.
and finish it up,
Yes,
all the
sir.
3 matters.
I do bound on yours.
Okay, put it on Monday.
Pardon.
Monday I can have, see, Bombay you.
You tell me, you
You
seek
tell-
instruction so that I can pass an order.
Yes, madam.
Monday I am saying, and Monday I am not asking for 10 lakh. I am only asking Monday you seek instruction.
18 goes to thou, 18 को था.
16. 18 बहुत matter.
रथयात्रा अरे सही correct. Let it be six.
No, what I am trying to tell you, I don't
Lordship,
want that you should get the 10 lakh rupees on Monday. You seek instruction orally. Monday I'll pass that order and give you sufficient time and send it to mediation.
Obligers.
Monday I'm keeping it.
Yes, yes.
Seek oral instruction.
Yes.
I'll pass a order and formalize everything. Let him.
Monday, lordship, I am
I
absent.
consider
Tuesday.
Tuesday, lordship.
Tuesday. Keep it.
Madam, pardon. Earlier order was also there. On 19/9/2013, realization of compensation amounts shall remain stayed subject to deposit of rupees 12 lakhs only by the person in the court of law and decision of Barampur Ganjam within a period of 4 respondents.
Now past, forget past. Now let us think of
On the very beginning, I have told I have leave it to my lord.
ultimately you need your money back.
I want my money back.
So we'll make sure that your money comes to you and
Mr. Ragad will be the mediator.
Tuesday. You just seek
Yes,
oral
yes, sir.
instruction.
Tuesday 9.
Huh?
9.
Hmm.
9th.
9. I will formally pass an order.
Madam,
and send it to
On that on my instruction provided.
Yes, yes. You
If
just communicate.
if possible, some draft with 3.
Monday, Tuesday may not be possible.
If possible, some amount.
If possible,
I am
let's try.
There is no order.
So that the client will not miss. So that the client will not misunderstand.
We'll see.
Client or you
We'll see and sort out this problem. We'll see and sort out this problem. Simply urgent to do.
Item 16. Please, Your Lordship, my lord, this revision is directed against the order of conviction, my lord. Convicted under section 409 and 5 years of conviction. But I pray some one time to so that I will take instruction and also prepare a short note, my lord. Keep it
Weekly list I'm putting it.
my lord.
Weekly.
Some time, 1 week or 2 weeks after, my lord.
You will get 2 weeks, don't worry.
Oh, bless. 17.
Something my please, my lord. In this case, my lord, are not fully prepared in this case. Challenging, my lord, the order of conferring the sentence 300 partly allowed by the some additional sessions court, my lord, 307.
You are appealing for?
For the informant. My lord, the informant also filed appeal challenging the appellate court order. In trial court, the accused person convicted under section 307 and sentenced to undergo 5 years. Injury grievous on head. In the appeal, the sentence part was conviction was maintained, but sentence part was reduced to 2 years. Challenging that appeal is
Undergone, how much he is undergone?
only at the during the trial, they were some days in custody, and after conviction, some days in custody. From the LCR, it will confirm that appeal is pending.
You are seeking enhancement of the sentence.
My lord. Appeal, my lord, CRLA 76 of 2014. Kindly list the matter along with this criminal appeal. So that both the cases.
List the matter along with the criminal appeal number
76 of 2014.
76 of 2014. Filed by the informant.
CRLA.
How many accused are there?
The total 6, my lord.
6 appeal.
Revision filed by myself all along all my lord accused persons.
One is 65, 35, 57 in the year 30, 57.
Now go to Morigalani, my lord.
Who?
My lord, I have taken instruction today, my lord, that over telephone, one of the accused.
Ramachandra Padi might have died.
I'm-
65 that time.
No, I'm not my lord, one of the accused, my lord, but therefore I have taken time so that concrete information I'll.
I'm listing the matter. You just revision will responsible petition submit that one of the.
না সেটা লেখা নথা ମୁଁ confirm କରିବି lord.
ठीक है,
खाली
sir.
along with the
Sure, along with correction. Of the after 2 weeks.
Item 18.
Conviction under Rule 21 of the Odisha Timber Transit and other forest produce rules. Sentence is 1,000 rupees fine to both the accused persons. Appeal confirmed.
Appeal confirmed.
Yes. So may I pray while maintaining conviction, if your lordship can consider releasing on PO Act.
And last week also you received this type of cases releasing PO.
The sentence, what was the sentence?
1,000 rupees fine only.
Fine only. So PO corner. PO what? PO 1,000 rupees. Why don't you pay 1,000? PO is same or paying 1,000 is also same.
Hey, I was torturing.
Sentence. PO is given to the sentence. Default. What is the default sentence?
SI for 2 months. Default. In default.
The PO is for only not to send you to the probation is granted when the incarceration is there. For fine, what PO?
In default of payment of fine amount each
That's
convict.
right. Yes, Mr. Ragada.
2 months.
For fine.
Fine also,
Fine also
amounts to permission.
default.
Conviction is there. PO doesn't. PO is only to avoid the incarceration.
Default sentence.
For that reason, if you will ballot the under PO manner, under observation manner, change his behavior or everything, and then only
1,000 rupees only. 1,000 rupees for you What is
ସେତେବେଳେ 14 ମସିହାରେ ଫାଇଲ ହେଇଥିଲା 2014 ର ରିଭିଜନ
no, so you successfully avoided too much.
And PO also appeal on conviction. Sentence, conviction.
One judgment is there, but that when service jurisprudence also that can be utilized.
yes
You did.
You will not come to him, my lord.
2014 I was not that matured like my friend
There
But
is copy.
in a
I would give
review-
the extra copy.
What is the sentence?
sentence 7 years
7 years.
I will grant PO in view of the settlement. Isn't it? Yes, Mr. Ragada.
My lord.
What do you say?
Settlement, yes.
They have
no,
settled
joint
their
appellate,
merits,
okay.
staying
He is
happily.
Why?
PO, that's the best case for PO.
Why
What else?
period?
You lordship.
Out of that, already 3.5 months already they are in custody.
Whatever, but 376.
Well,
So therefore, in a revisional jurisdiction, I can't record an acquittal
Mel
unless
You
there
can
is
reduce
clear. So,
sentence
but I
also.
can keep PO because of the
Mel
already undergone before. Already undergone
already undergone Miller 3 years 2 months
3 years 2 months. Sorry, PO लिख दी and settlement लिख दी settlement. That's
Obliged.
flag C.
ଏଇଟା କୋରେଟର କ୍ୱେଶ୍ଚନ
Flag
You're a pure
Flag C ଟା ଅଛି ନା ଫାଇଲ ଟା flag C ଅଛି ହଁ ଠିକ ଓକେ ଓକେ 21
21, I am praying for a Passover, my lord.
what is this matter?
My lord, this is a matter relating to the releasing of the 457, rejection of 457, releasing of the passport and other documents.
You argue what? You are the leader of the bar, you can argue.
My lord. My lord, here in this case, the wife is the trap case accused, my lord. And in that light,
You are seeking release up for 2,50,000 rupees.
my lord, that is in that locker key is with the Vigilance Department. And my lord, other documents, that is, the documents are the passbooks and ROR, sale deeds, ATM card and passport.
What
and
was
other
the reasoning given by the court below for rejecting the application?
My lord, the order is. My lord, part 20.
So, okay, I'll pass it over. I'll just pass it over.
My lord,
Page.
one,
Here.
I am not the Passover for. I prepare myself Passover.
Pass it. 22.
If this sanction is refused, till cognizance has been taken. Let's it me come to
Sanction refuse.
sanction. Let's me come to page
Offense.
PC Act and other page 20, my lord.
PC Act, huh?
Yes, ma'am.
19.
Yes, 9 sanction has been refused.
Yes.
My lord, and before my friend, just one point. This same, there are 2 persons against which the sanction was sought for. It was refused against both, notwithstanding that the trial court took cognizance. The other accused person approached before the Honorable Court in criminal revision. It was passed. And the vigilance has
That has attained finally.
attained finally.
Yes, sir. Who is appearing? If there are 2 accused, sanction refused, whichever 2 accused. One accused came to this court under the revision and cognizance order was quashed. That has attained finality. How can you proceed against this accused?
At the end of the day, my lords, my learned friend's submission can be summarized that in the absence of the sanction, whether the impugned orders taking cognizance is sustainable or not. Lord, my humble submission, my lords.
Same TR. And at page 20, my lord, lordship may find out his name. The second one, Shailendra Narayan Naik.
Only two accused in the FIR.
Many other accused are there. Insofar as sanction is concerned, this same point is concerned. They've sought for sanction against the GM DIC and the manager project, assistant manager project, DIC. Against both, the sanction was refused.
You are, what is your name?
I'm Stitikanta Sodangi.
Stitikanta Sodangi.
And admittedly, by the time...
Shalendra Kumar was not an accused, no?
Yes, my lord. Shalendra Kumar was accused. The lordship can return to that impugned order.
No, come to page 13. The FIR.
My lordship can come to impugned order, the name is there.
No, in the FIR, he was not there.
If here, my lord, if here there are several persons are there.
Mahesh Kumar Mahapatra.
Found Mahesh Kumar Mahapatra, Stitikanta Sodangi, Prasanta Kumar Parija, Niharanjan Parida, Surendra Kumar Parida.
T.N. Bhagat. 6 accused.
But charge sheet has been filed and your lordship can have that.
Charge sheet, where is charge?
No, cognizance order I have annexed. Page 21, your lordship find out. Number 2, A2.
Charge sheet might have been filed against him.
Yes, ma'am.
Yes.
Let's
Will you check it?
No, I've gone through. In fact, coincidentally, I was
senior was arguing.
No, my lords, may I submit one thing, my lords? My lord, the essence of my learned friend's submission is that in the absence of the sanction, the impugned order taking cognizance is not legally sustainable. My humble submission before lordship is, my lords, that the petitioner before lordship, my lords, is the principal accused, my lords, and the role he played, my lords, his exact complicity is, my lords.
Role,
That
you forget about role.
wait, I'm coming to the sanction person. But now the lordship can,
in the absence of sanction, can you proceed?
No, it's not filed. This only instruction I received. This gentleman, the petitioner for lordship, my lords, was the general manager, my lords. Was the general manager, and in fact, he was at the time of that occurrence, my lord, he was holding that post, my lords, a general manager of DIC Jagatpur, my lords, from 10/6/2005.
Then
From
he had retired by that time. That's what he was.
that is one. That is one. Second, my lords, from 10.
File a response taking in.
My lord, may I submit, my lord?
May file a response.
No, may I submit, this particular judgment, my lord, suffers from the principle of, in fact, I would take the grounds of subsilentum, lords. A particular question of law could have been taken in that earlier case, could not be taken off. That's the judgment is good so far the fact is upon
That's what
that
I'm
particular
saying.
case. But so far this case is concerned.
Take this judgment and this one, file a response. Mr. Das, petitioner, seeks 1 week time to file response to this petition. Let him file a detailed response. Taking into consideration the fact that one of the police persons had approached this court challenging the cognizance order in the absence of the sanction. In the absence of sanction, this court, by the order dated 3/10/2020 in criminal revision number 883 of 2019 has quashed the proceeding against the accused person. In the present case as well, sanction has not been refused. Sanction has been refused. Mr. Das and counsel for the petitioner submits that the present petitioner was working at GM.
DIC. District in
Jagatpur from 10/6/2005 to 9/7/2000.
The cognizance was taken.
And he has demitted office on superannuation in the on 2nd July 2000.
And the cognizance was taken on 11/7/2019.
And the cognizance of the offense has been taken.
Particularly when he was not holding the post abused.
Give the date. Cognizance is taken on
11/7/2011. 19, my lord, sorry. At page 24, 11/7/2019. On the ground that he was not holding the post abused at the time of taking cognizance.
Then the other judgment of the honorable
Why have you
apex.
gone for sanction then?
Beg pardon?
Why have you gone for sanction? It was rejected. Sanction order is there?
Yes, ma'am.
Rejection sanction order.
Yes.
You deal with that.
In fact, the other honorable apex court judgment that sanctions once acts and refused, then post retirement, cognizance cannot be taken. Our own High Court say yes.
I know that's the reason I am asking for it.
Chittaranjan Das, and I have already given it's on record.
He has to deal with that.
Already.
This has gone to Supreme Court.
Yes, and our own High Court say yes, he can take in cognizance.
I will.
Not asking for sanction is one issue. Once it is asked and refused is a different.
And exactly our own High
You
Court
have to deal
says
with that. You
that
went, your own officer says no sanction is required, refused. The consequence is different. That you have to deal. Next week, file a response. If you not have sought for sanction, things would have been different. You could have justified. You sought for sanction, a detailed order is there, refusing sanction, then yes, next.
The revisions here, my lords. When the revisions were filed, the petitioners had assailed an order of the Special Judge Vigilance dated 18/10/2022, rejecting their prayer for discharge. During pendency of the revision before this court, my lords, the learned Special Judge by order dated 20/12/2022 has been pleased to frame charges against petitioners. So therefore, in each of these three cases, 3 IAs have been filed for amendment. Here, IAs.
Challenge that order of.
Yes. Those IAs, my lords, no orders have been passed. In the first revision, that IA is at flag B, IA 1.
Yes, Mr. Das. They want to challenge the charge order. See, they moved an application for discharge, it was rejected, they filed revision.
In the meantime,
During the
charge
pendency, charge has been framed.
Charge and framed.
They want to challenge that. Either they can file a fresh one or move application. Why to burden? Allow the application.
I agree, my lord, but another proposition can be explored, my lords. Can be withdrawn and the fresh application can.
That is their discretion. I can't.
Only wastage
I can't advise them.
I also don't stand on the way, but there's no harm, my lord. It can be disposed.
You pursued them.
File a fresh one. My learned senior knows, my lord. For filing a new application, they can innovate and go for a fresh grounds also. That's another advantage.
No, it's not to our advantage. Let the amendments be allowed.
Right. All the three?
Yes.
Okay, similar order like the petitioners have challenged the order by which their application for seeking discharge has been rejected. Meanwhile, during the pendency of the present revision petition, charges have been framed against the petitioner. In view thereof, the petitioners have moved the application seeking amendment of the prayer in the revision petition. They seek to assail the order of charge framed against them by the order dated so and so. In Tinta matter.
Lord, sir, may I submit
the matter for hearing? You filed response.
Lord, may I submit, my lord, sir? Now only 3 cases in the list, my lord. Another revision 726 of 2018 also. No, read that, my lord. Only my lord, sir. Dispose Lordship, I request my lord, but miscase copy it. And the date of framing of charge.
When can you argue?
Date when the charge is framed.
This matter, no long date. You argue and
No,
finish.
no, no, your lordship can give us
You-
1 week after.
You fix the date and tell me.
This is July.
We're talking about July only.
Yes. And we have it on the 18th.
18th, a lot of matters are there.
Then
18th,
16th.
16th, okay. 16th at 2 o'clock.
Yes.
16th at
That's,
2 o'clock. Come prepared and finish it.
all the three cases, charge has been filed on 20th,
22.
22.
Briefly, please.
Because their own IO Millers in his charge sheet has shown that there is no case against us.
It is their own case, not our case.
Still he files the charge.
Again, it's their own case.
He should have filed a closure report. Because
We should have taken the witness. They should have called us witness for them.
Cited us as
Witness for them.
Instead of that.
And still you can consider to,
Again, we are ready, bro.
you can be approvers. Yes.
24.
May I please, your lordship? My lord, here in this case, the last observance, the Honorable Court instructed for the regarding the link of the money trail with the bank accounts of the present petitioner or not to take instructions regarding that. My lord, here in this case, this,
What is this case?
my lord, regarding the freezing of the bank accounts, the 457 filed for the defreezing of the entire bank accounts. That is the order, the person is aggrieved by the order dated to, my lord, the person is aggrieved by the order.
You are accused.
My lord, I'm the accused person in this case, and the person, the bank accounts has been kept on frozen, and the person aggrieved by the order dated 21/11/2022, in which the para 9, my lord.
Para 9.
My lord. It stated that in the view of the above discussion, I am inclined to allow the petition of the accused petitioner in part. Accordingly, the petition filed by the accused petitioner under section 457 is allowed in part with condition keep balance as on 2/6/2021, not to misutilize the above liberty. That is the order, my lord. They are partly allowed.
Allowed in part.
My lord.
With certain condition.
My
Then
my lord, my humble submission before you.
lead by the condition.
My lord.
What are the conditions?
My lord, my submission, the bank account entirely defreezed, my lord. My lord, they have not followed the procedure of law while freezing of the bank accounts. As
You are
per-
agreed by the condition imposed or the entire order?
My lord, not, I am my humble submission to defreeze the entire bank account, not to that condition, the keep balance was on 2/6/2021. That is my.
Very 2/6?
To the first condition, keep the balance as on 2/6/2021.
Where is that?
My lord, running page 18,
Uh,
para 1.
Para?
Running page 18, condition 1.
The second paragraph from the bottom. To keep the balance in those bank accounts as on 2/6/2021, that's the date of the house search, intact until further. So they can operate that accounts.
My
They can operate that account except this particular amounts, which
Whatever lying as on 2/6/2021,
My lord, the person.
that will be freezed.
yes, but that pertains to the D
You
amount.
can,
My lord, the
What
person
is wrong in it?
My lord, my lord, the person is after that retired from the job, my lord. So my lord, there is no point to keep that account frozen, but the account cannot be, my lord, without due process of law, the account cannot be frozen. My lord, as per the 102.
102, they might have followed.
My lord, but the affidavit stated that the account, the forthwith, you have to state that forthwith immediately inform the magistrate.
When was
The
it was
account,
seized?
my lord.
When it was informed to the magistrate?
My lord.
Where?
That the affidavit does not keep silent about
Have
the
you
same
followed
fact.
102?
No.
Show me. That's the only argument here.
Right.
You have not followed 102.
We invoke that only.
No, you have invoked not followed subsequently. Because once seizure is under 102 only.
Yes.
Thereafter, the procedure is laid down in 102 itself. You have to inform to the magistrate forthwith and all. Have you complied that? That is the only thing.
I mean, the total 102
Procedure-
procedure
Yes.
is to be complied, my lords.
Whether you have done it or not, that is the only complaint she has. If you have done it, done it. If you have not done it, you have not done it.
That affidavit was filed, but that particular line is missing. I'll call for the officer to come with that.
For the petitioner submits that the freezing of the bank account is divorced the procedure contemplated under section 102 CRPC. Therefore, the is assailing the order of freezing of the bank account bank account. Also, she has her client had moved an application in section 457 CRPC, which was turned down, and turned down. The said order is essential. Mr. Das, Lankon for the opposite party submits that the procedure contemplated under section 102 has been complied. However,
To that effect,
affidavit is not happily.
To that effect, I will find an
happily
affidavit.
worded. Therefore, not happily worded. Therefore, he seeks 1 week time
To file specific affidavits.
Specific and detailed affidavit. Inter India, narrating the particulars and the details of compliance of section.
Embodied in section
compliance
200.
requirement of section 102 CRC. Please the matter. Approve.
The case from Rahul Kula, the officer will come. Rahul Kula also fix a date, my lords. Rahul Kula also.
Next picture. Yes.
25.
Yes.
The petitioner has challenged the discharge petition rejected by the court below, your lordship.
Page 63, my lords.
Now charge has been framed.
No, no, on
No,
16/10/2023. 16/10/2023 has been fixed for framing of
The date is fixed to tomorrow, your lordship, for framing of charge, your lordship. Here, your lordship, the court has arbitrarily rejected my 239 application, your lordship, though there is no ingredients of any offences available against me, nor I was involved in any such kind of transactions, your lordship. The fact, your lordship, the petitioner was working as that marketing inspector in charge of Junagadh DPC, your lordship, as Kalampur block was also coming under him, your lordship. And he was appointed as a district marketing in charge and procurement officer for the district procurement committee, your lordship. They procured paddy from the farmers, your lordship. So one Balram Sethi, who was also marketing in charge of Karlamunda DPC, your lordship, he too procured paddy from Karlamunda block, your lordship. As per the direction of the authority, your lordship, all the paddy that they have procured, that was handed over a miller who was at Keshinga, that is one Balaji, your lordship. Balaji Mill, your lordship. As your lordship, one enforcement officer was engaged to look after all this, all the activities done by the miller, your lordship. The miller didn't handed over the custom milling rice to the OSFC, your lordship. That's why the present case was registered. This is a case of 2008 and 9. The FIR was registered in the year 2011 for non-delivery of custom milling rice by the miller, your lordship. Here, your lordship, I have initially FIR was registered under section 13(2) read with 13(1)D, 409, 406, and 120 BIPC, along with 7 of EC Act, your lordship.
Yes.
As because the miller was not, that he didn't deliver the custom milling rice, your lordship,
and one enforcement officer was engaged for that purpose to look after the activities of the miller. But later on, this petitioner was implicated as because he was procured rice from the farmer, your lordship. There is not a single allegation against the petitioner whether during the course of procurement, whether he misappropriated any amount or what he procured he didn't deliver to the miller, or the miller what he received that is less than or excess of that procurement what he made. That was not an allegation, your lordship. Because the miller didn't deliver the rice, your lordship, person meaning rice, that's why the petitioner was implicated. And your lordship, initially FIR was registered against 5 persons, your lordship. Page number 17, your lordship.
Show me the charge sheet.
Charge sheet, that is, and starts from annexure to page 22, your lordship.
Show me the allegation against you.
Yes, your lord.
What are the allegations against us? Come to page 39.
Should I read your lordship? The brief history of the case is that the case was registered on the written report submitted by me following inquiry in Koraput Vigilance file number such and such for misappropriation of quintal 9710.82 of CMR for KMS 2008-9 worth of rupees such and such. Economic rate of such and such per quintal by Sri Sibo Das, ex-CEO, CSO, Sri Surya Narayan Padigre, ex-ASCO Karandi, enforcement officer of the custom mill, Sri Khogeshwar Ponda, ex-MI of Junagadh block, Sri Balram Sethi, ex-MI of Korlamunda block, in convenience of Miller Sri Ramkumar Jain, proprietor of Sri Balaji Agro Product Plant. Investigation reveals Sri Khogeshwar Ponda, that was the present petitioner, was MI in charge of Junagadh DPC and Kalampur DPC, where Sri Balram Sethi was MI in charge of purchase officer of DPC Korlamunda. Sri Sujanan Paniga was ACSO, ex-enforcement officer Kalandi. He was entrusted as the enforcement officer of Balaji Agro Product Korlamunda Kesinga. Sri Sibo Dora was posted as CSO cum DM Limited OCSC Limited Kalahandi Bhavanipatna during Kharif marketing season 2008 and 9. Sri Ramkumar Jain, proprietor of Balaji Agro Product Limited Korlamunda Kesinga. Sri Sibo Dora was CSO Kalahandi Bhavanipatna and Sri Suryanarayan Panigrai, CSO Kalahandi Bhavanipatna were entrusted to verify the stock of paddy and CMR and to ensure the delivery of CMR by the proprietor of Balaji Agro Products Plant, Korlamunda Kesinga, by letter number such and such of Collector Kalahandi. This is very important also. The duty of the enforcement officer was also submitted to submit the time-to-time checking report of stock of paddy and rice, meter reading, and other irregularities found in the running of mill periodically for each week, fortnight, and month. During KMS 2008-9, the duty and responsibility of CSO cum district manager OCSC purchase officer was fixed as per guidelines issued by letter number such and such of managing director, Odisha Civil Supply Corporation Limited. Duty and responsibility. That was enumerated, your lordship. Duty and responsibility. Page 42. Investigation reveals. Second paragraph, your lordship. Investigation reveals that Sri Ramkumar Jain, proprietor of Balaji Agro Products Plant, entered into an agreement with DM, district manager, OCSC Limited, Kalahandi, on 25th November 2008. As per the agreement, the custom miller will lift the paddy on the same day of purchase of paddy or at best the next day and complete the delivery of rice to corporation maximum within 14 days of delivery of paddy, as admissible to him, failing which he will be liable to pay holding charges of the corporation at the rate of 20 paisa per quintal of rice per day.
Come to next paragraph.
During KMS 2008 and 9, Sri Khogeshwar Ponda, MIISC in charge, Junagadh and Korlamunda DPC, has procured quintal 29,696.96 paddy, quintal paddy during Kharif and such of paddy during Rabi season from DPC Junagadh. He also procured such and such paddy from DPC Kalampur. Likewise, Sri Balram Sethi, MI in charge of DPC Korlamunda, has also procured such and such of paddy total of quintal 60,153.173 of paddy was supplied on different dates by the 3 MIs to Balaji Agro Products plant situated at Korlabadi, Kesinga for custom milling of rice. Sri Ramkumar Jain, proprietor of Balaji Agro Products plant, who received such and such was to return 40,904.54 to OSSC Kalahandi is equivalent to 60% of the paddy of the OCSC Limited Kalahandi. Scrutiny of the statement of custom milling rice, KMS 2008 and 9, and report submitted by the assistant manager OCSC Limited Kalahandi, it is ascertained that the custom miller has delivered quintal 31,193.72 out of quintal 40,904 till 30/11/2010 and is due to return such and such CMR as per FI. That is the shortfall, your lordship. Sri Khogeshwar Ponda, MI in charge of Junagadh Kalampur DPC, arbitrarily delivered 24,509 quintal of PD to Balaji Agro Product Limited Kesinga, that is quintal 80 of DPC Junagadh, and quintal 8,695 of DPC Kalampur without the order of the collector Kalahandi or DM OCSC Kalahandi, violating the official norms during KMS 2008-9. On verification of SC note, CMR statement or other relevant document, it is ascertained that the purchase officer Junagadh has last issued Kharif
Come
paddy
to page 44. The top paragraph, last 3-4 lines. Though the time was allowed to the miller,
Yes, your
he
lordship.
has failed to
That-
deliver
that-
CMR.
that- that-
But without
Your lordship.
direction.
Lordship, then
From the
I
collector
will read from page 43, your lordship.
No, just see the complexity you have or not, just see you have without taking sanction from collector and all, you proceed and
Lordship, that's a wrong thing, your lordship.
store the petty of.
No, that was done by the collector. Your lordship may peruse. Your lordship, page 43, your lordship. When the civil supply officer did not take any step for physical verification, 43, your lordship.
All these things are tribal issues. You can't.
This disclosed prima facie great suspicion with regard to the complicity of the petitioner in the alleged offense, particularly the way he has the conspiracy.
Without
Let me have my.
Without direction from the collector, Kalahandi, and DMSO, OS so, Sri Khogeshwar Ponda, MI, Junagadh block, in charge of so, procure paddy for Rabi session 2008 and 9, and deliver the same to Balaji Agro.
Yes.
That
Complicity is palpable complicity.
Lordship may peruse. That the last paragraph. I'm reading, your lordship. Thereafter, letter has been issued by letter number such and such by the CSO Kalahandi to proprietor Balaji Agro Product Kalahandi to deposit the cost of shortest quantity of paddy and rice within 7 days of receipt of the letter. The managing director OCSC Limited Bhubaneswar has intimated by collector Kalahandi in his letter number such and such, dated such and such, regarding shortfall of rice and paddy, and notice issued to the defaulting customer miller by letter number such and such. Mrs. MS Balaji Products Karlavadi was not allowed to participate in KMS 2009 and 10. Further, all the claims bill due against him had been held up till realization of the cost of the above shortfall rice and paddy was verified by the district squad. After receipt of letter such and such, the proprietor MS Balaji Agro Products has submitted a letter dated 3/12/2009 to CSO Kalahandi. That is not me, your lordship. I was the MI. I was the marketing in charge.
All these things.
Part of conspiracy.
Lordship may peruse.
Then I am conducting a trial now.
No, mini trial is not permitted.
That part I will come, your lordship. That part I will.
20B is there and everything.
CSO Kalahandi, Bhanipatna, stating delivery of CMR within 1 month in case of any shortage, then his returning bill may be held up for recovery. Further, MS Balaji Agro Product has requested in his letter dated such and such to DMOCSC, that is district manager, not to me, your lordship. He has requested to the district manager, who is also accused in this case. District manager Kalahandi for granting some one more time. He has written letter to district manager, not to the present petitioner. The petitioner.
That's right. All these things has to be.
And your lordship, one more point, your lordship. Your lordship, my page 9, your lordship. My grounds, your lordship. that is ground E, your lordship. I was suspended in a different allegation from 27/9 to 6/7/2010, your lordship. In this period, I was not holding any office. My headquarters was fixed to Bhanipatna.
It's a difference play.
Bhanipatna, your lordship. Later on reinstatement, I was posted at Navarampur, your lordship.
It is for 2008 and 9.
Yes, your lordship.
You are from 7th July.
Yes, your lordship. 27 July 2008.
Previous year.
No,
Allegations
that
are
same
for
year, your
previous
lordship.
year. Allegations are for previous year.
It's not a groundless case, my lords.
Your lordship, that the period when he was suspended, that was the period when the miller was about to was fixed to
But the
deliver the
offense
customary
had
rice.
taken place in for 2008 and 9.
8 and 9, that is the procurement season, your lordship.
And that season only it was procured.
That is the
It
end of
germinated-
8.
It
That is,
germinated from there.
that is up to the April or May of 2009, your lordship. I suspended
July.
in
July.
July. When the miller was about to deliver the custom milling rice.
No, but
And I was the marketing in charge, your lordship. My role was only to procure and to give to the miller.
That you give.
My role was not to get the custom milling rice from the miller. And there was an enforcement officer who was appointed for that purpose.
I know, I understand it.
And your lordship, by virtue of collector's direction, the enforcement officer went to seize the bill, your lordship. He seized everything. And he didn't find anything, your lordship. Though in the earlier occasion, the collector has directed the enforcement officer to go and to have a physical verification. But he
Why don't you simplify your argument? If so many things are there, then it has to be tried. You are complicating your own case.
Lordship,
Simplify. Tell me in one sentence what is your case. Then is a case of discharge. If
Yes,
so many
your
things are there, then it has to be tried.
I have been implicated, your lordship, with a malafide intention. There were 2 MIs. I have been implicated in this case. The other MI was scot-free, your lordship. It is the prosecution case. We procured ready and we gave to the miller, and miller didn't deliver the custom milling rice, your lordship. It was their case. The 2 marketing inspector has procured the rice, your lordship. Though I was implicated in this charge sheeted, your lordship, the other one was scot-free, your lordship. 1.1, your lordship. Point 2, our role was only to procure the rice, your lordship, not to ensure about the custom milling rice. One enforcement officer was appointed for that purpose. The prosecution doesn't have any allegation regarding the quantity of procurement, your lordship. Whether what we procured was that is not the delivered to the miller, or the miller has received less than our procurement, your lordship. That is not the case. It's a case that the miller didn't deliver the custom milling rice to the OCS, your lordship.
Yes, Mr. Das is.
My lords,
He's going here and there.
My lords,
But his only argument is procurement is not the crime. Crime is non-delivery of the rice.
my lords,
And he has procured, and there are system and inspection and everything is done. Since the offense is non-delivery of the processed rice, the procurement persons involved in procurement cannot be prosecuted. And particularly 2 people were responsible for procurement. You are selectively prosecuting him and leaving the other man out.
my lord,
This is his own case.
that is his case.
He's
My lord.
reading here and there and all.
My lords, I appreciate his endeavor, my lords, to make out a case for him. But this is a case, my lord, where the petitioner is a part of the conspiracy with another assistant civil servant officer and the CSO, my lords. The co-accused persons.
The procurement is crime or non-delivery of a process.
Both, my lord. He is involved, and this is a conspiracy cannot be proved, my lord, by direct evidence. It has to be informed of different circumstances, my lord. In this case, my lord,
Is there
there are
any
materials.
irregularity in procurement? Simply answer me. Whether there is any irregularity in the procurement, because in the procurement process he was involved. See,
Let's
there are
say-
2 steps. Rice are procured from the agriculturist, given into the rice mills. And the rice mill has to process it and give the rice in the market. And there should be a coordination between that. What is procured and what is given.
Madness.
And he is involved in the procurement process, the marketing procurement process. There is nothing found wrong in procurement. And the only what is found wrong is in the delivery of the rice.
No, he's a party in that
Delivery of
conspiracy. my
rice
lord.
is done
So
by
it-
the Balaji.
all
Balaji.
the offenses committed here, my lord, cannot be done by one person. They work in tandem. They work
If the procurement was the crime, then why you let off the other?
That is a different issue, but that will I will take instruction on that. But so far, his complicity is concerned, that is palpable. The reason being, my lord, if had it be a case, my lord, that is absolutely no ground, my lord, no materials against him, lord. He was working in hand in gloves with other assistant cooperative civil supply officer and civil service officer who are the both public servants, and also the Miller Ram Kumar Jain, my lords. And they in order to mind Mullers, they has a conspiracy secrecy, Muller. Now, if at this particular stage when the consideration of this application, Muller, direct evidence is to be procured to satisfy him that why other was let off, why I'm not. Are you holding a groundless case?
Show me the authorization you have to deliver it to Balaji Agro after procurement.
That was
No
that
authorization.
that was the agreement done between the
He was done in a-
district
You
manager.
are supposed to take permission from the collector
It's
Yes,
a-
sir.
to deliver it. How have you delivered?
in a clandestine manner.
How have you delivered it to Balaji Agro?
As per the direction of
No,
the
no,
authority,
no,
your
no,
lordship.
no, no. They are the case.
Show me that direct.
I will.
That is the allegation. Which
Everything is
again
stopped
I'm
there.
saying, though the time was allowed to the miller, he failed to deliver CMR first. Next, but without direction from the collector Kalahandi and DM so and so, Sri Khogeshwar Panda, MI, Junagadh so and so, and in charge of so and so, procure the paddy from the Rabi season of 2008 and 9 and deliver it to the Balaji Agro.
Your
There are
lordship.
two stages: procurement and delivery. You procure from the agriculturist and deliver it to a
Surreptitiously.
particular miller.
Yes.
And the delivery has to be done on the basis of instruction, written instruction. Where is that instruction?
Your
The
lordship.
allegation against you is there is no instruction.
Correct, lords.
Yes, your lordship.
And my lords, so far that this particular plea, my learned friends come, this is
See, when you
nothing can be,
when
this
you
can,
are arguing
it's a
against
defense.
a case of discharge, if you complicate on facts, then no court is going to give you relief. Because if complicated facts are there, it has to be tested in the trial only.
Yes, sir.
You have to make the case very simple, as practicable as possible. Use limited word and express it.
Yes, sir.
You are taking me here and there, and there's so many things, so many documents. Then I have to conduct a trial here.
In fact,
Is it permissible in a?
you already dealt in the different matters, and in fact,
Because you are not
clinching
focusing
the
what
issue.
exactly the allegation and what you prepare once again. I'm giving you time because he's making an attempt.
No, I agree. That's why I say I put on record my appreciation is endeavor, but I'm afraid my lords is holding a groundless case.
Try to point out your case in a simplest and minimum words. Then you succeed. Sir will tell, sir is sitting there, senior. Whenever you are arguing in a revisional jurisdiction, challenging the discharge, you have to make it simplify. Otherwise, see, if so many facts are there, so many documents are there, the revisional court can't go and check everything and conduct a trial and pass a favorable order.
At the cost of
Obviously, it looks like that it needs a trial. to
fix a date.
What is the trial? What is
not
right, what is wrong has to be ascertained. That's what the trial court job. In a revisional jurisdiction, I am sitting. Can I go into all documents, read, underline,
Pros and cons of the
flag, and then I say that no, you are
probing inquiry.
I can't do that.
Let's say fix a date. My learned brother is sweating profusely.
No,
He's coming out.
You tell me the date now. Now I made
any day next week, your lordship. But it's because the date is fixed for tomorrow for framing of charge, your lordship. I may be allowed to file an application.
No, he can make a adjournment.
Adjournment and
He can pray for an adjournment.
No, I am not saying anything. Simply adjournment.
Otherwise, the charge will be framed tomorrow, your lordship.
Otherwise, see, this is pending since 2023. You could have taken a stay. No court has given you stay. Today you ask you, I'm not with you, and you are asking for
your
stay.
lordship,
I'm not with you today. I'm just accommodating you because you are trying. You must try. No problem.
I agree.
Next week.
I agree.
Next week.
I will file an
No,
adjournment
you
petition
fa-
that will be considered.
Aरे,
For a week at least.
whatever.
ଆପଣ କହିବେ ଏଇଟା pending
Charge
ଅଛି
is
ବୋଲେ
framed, you can amend this petition also. Yes.
Yes, sir.
26.
You're not able to make out any case so far.
but he's trying hard.
Trying hard, therefore I'm giving.
He's profusely sweating.
Therefore I'm giving an opportunity. He may, I know the point. Yes. Yes, sir.
Last topic is also currently checking instruction. I
Yeah,
petition for increase of the account.
Man, this is my, I fairly agree, my lord. This is third time I am putting my learned friend in embarrassing situations, my lord. These two cases, my lord, about that 457 application, I'll take instruction and come back. I think he can afford to wait.
I am the brother of the accused, my lord. My account has been seized. I have sold my property.
Both the cases belong to my learned friend.
And that was in my account.
26, 27.
When?
26,
Why we have last opportunity?
Lords may fix it to 15 that case is 19th.
Instruction ଆପଣଙ୍କୁ
I must say this is a big case. 19th house.
Mr. Das again seeks an adjournment to get instruction by way of a last and final opportunity. One more opportunity is given to Mr. Das to seek appropriate instruction in this matter. Lease the matter on. You give the date where you can get it.
19th, I think.
19th. Yes.
second matter also same.
Both the matters.
But one possible matter is there, if Lords can take. 21 minutes, if that is being taken out tomorrow, day after tomorrow, I will be free after lunch.
21, what is this matter?
21 minutes, my Lord friend pray for that. This is also again.
He has asked it to will urgent. Yes, next. 20?
28. Yes. 28.
21 or some other day minutes.
21. Yes, sir.
I may be apologize for that, my lord. I could not attend the court last. Okay. Who is the?
Anyway, he is not.
He's coming.
Yes. Yes, sir.
In this revision, the confirming judgment is under challenge. The petitioner convicted for 6 months RI for commission of offence under section 324. 324.
24.
My lord. And 1 year for 325, my lord. The allegation is there is
Then you are convicted under 324 and 25.
My lord.
And 6 months is for 24, 1 year for,
For 25.
Confirmed by the appellate court.
Yes, my lord.
Incident is of which year? 2000. 2000.
2000.
Yeah.
My lord, I don't have the deposition copies, but so far as judgment is concerned, appellate judgment.
In 2000, you were 32 years.
My lord. And we read out the relevant portion of the judgment of the Lord and appellate court.
What is your case? Tell me about it.
Case is there was 4 to 5 friends. The informant and the injured both all are friends. They were gossiping in the nearby road village. Sudden there hot discussion, and the present petitioner gave a teeth bite to the lip of the informant.
What bite?
Tooth bite.
Okay.
To the informant. As a result, sustained the injury on the lip and lost cutting teeth and a hair loss. And so far as the
What the doctor says?
My lord, PW5 is Dr. My lord.
PW5, the doctor who had examined who had examined the injured PW6 on 16th 12 2000 at about 10:35 on police occasion and so and so. One lacerated wound of size 3 inch by 1 inch, skin depth situated over lower lip, and that one incised tooth of the lower jaw was also found missing, with fresh bleeding.
What is missing?
The
lower
teeth,
lip.
cutting lip,
Earlobe.
cutting teeth. It is further
in the evidence of PW5 that the age of the injury is within 6 hours back. Time of his exam of the time and that on 27th January 2021 he had given his final opinion relating to nature of injury, that is simple, where he had already given his opinion about the nature of injury number 2 as grievous. He had proved
how much you have already undergone?
My lord, I have no instruction, but so far during the pendency of this application, the petitioner was arrested on 31st May 2011 and released on bail by this honorable court on 5th of August 2011.
3 months, about 3 months.
About 3 months. During trial or pre-trial conviction, I don't have any instruction. I sent a letter, but it is address is not found. No instruction taken by my court. But so far as teeth bite is concerned, missing of a tooth is impossible, my lord, unless there is any thrust.
But if the doctor says it is grievous hurt,
One is
the court
grievous.
can't say that no, it's
Yes,
not grievous. it is
yes,
simple.
sir.
Doctor evidence is doctor
Yes,
evidence.
because
So
of
I
I
can't
don't have the
substitute that.
deposition copies, whether the doctor has cross-examined or not. It may be caused by falling on the ground.
I don't know what was the do you have the trial court record with you?
My lord.
You have.
No, I don't have, but if you lordship,
It is there, you can just see.
my lord.
Shall I take it at
After
2
lunch.
o'clock?
My lord.
You just sit. Huh?
My lord. Highly
Just,
obliged.
it's there. Just read it, note it down.
My lord.
If you can do something, we can reduce it to the sentence. We can reduce to already undergone.
My
3 months he has already undergone. Just take it up if during trial if you have undergone something.
Yes.
Then we will record it and charge on PO.
Maybe acquitted by your lordship. Maybe on 323.
You are very ambitious that.
And previous occasion I am dealing this file matter. It a fit case for PO, but not Same doctor evidence is there.
Doctor evidence is there.
And a corroborated
Eyewitness and
Let me verify.
One injured is a grievous.
anything. Miscellaneous. 29, 30. Just see 29. Who is there in 29? 29. Yes. Are you ready?
No, after I have written the party one day before yesterday. He contacted me. What is after for assume
1 week for okay. 30. I am there.
376 launch per hour.
Launch for it.
ମତେ 10 ମିନିଟ ଲାଗିବନି 5 ମିନିଟ 10 ମିନିଟ
ଯଦି କହିବେ ମୁଁ ଅଛି
ଲଞ୍ଚ पर करियो
ଆଜି ଉଠିନା
ନା କାଲି କरियो कोन तू
ମୁଁ ଆଜି ରେଡି
ଅଛି କାल ଲଞ୍ଚ पर करियो
আমি कुछ करी
लंच पर करियो यू
ନା ନା କାଲି କାଇଁ ମୁଁ ଆଜି ରେଡି ଅଛି ଫେର କାଲି କାଇଁ ଆସିବି ଏମିତି କରିବି ମୁଁ ସାର ଦେବି
immediately after lunch.
after
one case is there for DRT. I will
Oh, you
come
can come. I can come. I will pass. We will wait for you.
No, I will come back by 2.
It's all right. You attend that matter.
Yes.
Then you come. No problem.
Okay. এটা কোডটা খসিগলা খসিগলা পথ
Who is appearing for the other side? Mr. Rijvi?
My learned friend. But he is suffering, he has suffered a lot, my lord. That's
Item number?
170. My learned friend has also filed written notes of submission. I have also filed. Paper book is ready. Only my lord 10. Fix a date so that it can be disposed on the same date.
You tell.
23rd.
Tomorrow, day after tomorrow is this week, anytime?
Any day.
This week, how many matters?
This week is there.
Is there any specific
Many
date?
prefix matters are there, ma'am.
Huh?
Many matters are fixed on 4th also, ma'am. So this.
You do one thing, you speak to him, fix, arrive at a consensus and tell Mr. Jyoti to fix it.
On 9th, 10th, any day. We can discuss and we will intimate.
Yes.
My lord. On my default of last occasion, Mr. Mohanty, my learned friend, was appointed as amicus curiae, and he is present with all preparations. No.
If you have already prepared, both of you.
Yes, my lord.
Yes, have you given
Due
it?
to some personal difficulties, I was.
One minute, since you have already prepared, you double up, so he will join with you.
Yes.
Yes.
The FIR allegation is like that, my lord.
Yeah,
No, mote sir ko jara karne. We are along with.
Written, he has prepared a written submission.
Yes.
Just, you develop the written submission, whatever.
Yes, sir. I am obliged to him.
Yes. Please wait, please see, take your seats and assistant.
Yes.
Yes. Yes.
The FIR is like that. ମହାଶୟ ଲେଖି ଜଣାଇବାର କାରଣ ଏମନ୍ତ କି ଯେ ଗତ 16/12/2000 ରାତ୍ର ପ୍ରାୟ 9 ଘଟିକା ସମୟରେ ଆମ ଶିଆଲଝୁରି ଗ୍ରାମ ଦାଣ୍ଡରେ ଶ୍ରୀମତ ଛତ୍ରିଆ ଶ୍ରୀ ରିକୁ ଭୁଏ ଓ ସାଲେଗ୍ରାମ ସଲମା ଦି ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଏହିପରି ଆମେ 4 ଜଣ ବସିଥିଲୁ। ମାମୁଲି କଥାବାର୍ତ୍ତାରେ ସାଲେଗ୍ରାମ ମତେ କାମୁଡ଼ି ଦେଲା। ସେ ଏପରି ଭାବେ କାମୁଡ଼ି ଦେଲା ଯେ ତଲି ଚଣ୍ଡ ଖଣ୍ଡିଆ ହେବା ସାଙ୍ଗେ ସାଙ୍ଗେ ମୋର ଗୋଟିଏ ଦାନ୍ତ ମଧ୍ୟ ଭାଙ୍ଗି ଯାଇଛି। There is no blow or anything, or blood had weapon has not been used as per the FIR. Only teeth bite is there. And so far as doctor's opinion is concerned, my lord.
Yes.
The cross-examination of the doctor. PW5 is the doctor.
PW.
Injury number 1 and 2 can be possible by fall. But the said injury, it is not readable, my lord. Maybe associated with this injury, so and so. Injury as stated above may be possible by fall on hard surface.
Okay.
And the peculiar thing in this case, there was at the spot there is 4 persons present, but no prosecution witness is treated as eyewitness. Nobody is claiming their eyewitness. All are had the occurrence and found that the lower lip is injured, one teeth is missing.
Then there is no eyewitness.
No.
This is what. Yes, Mr.
My lord, FIR says a lot. This by this Madhu Gubala was PW6. He has stated that Amma Kamadandra Simot Kshatriya, Riku Bhui, Telegram Salman. This
PW6.
Yes, PW6 is the informant. PW4 is also eyewitness because he was present. PW4 is Srimant Kshatriya, Satina. He has cross-examined and declined.
Declined.
ମାମୁଲି କଥାବାର୍ତ୍ତାରେ ସାଲେଗ୍ରାମ ସଲମା ମତେ କାମୁଡ଼ି ଦେଲା ଏପରି ଭାବେ କାମୁଡ଼ି ଦେଲା ଯେ ମୋର ତଳି ଖଣ୍ଡିଆ ହେବା ସହିତ ଗୋଟେ ଦାନ୍ତ ମଧ୍ୟ ଭାଙ୍ଗି ଦେଇଛି। So that even my friend has submitted that injury and
one injury, simple one is grievous.
Yes, sir. Yes.
Injury number 2 is grievous.
And but the opinion is the injury is as stated as possible by fall in hard surface. hard surface. And so far as that 5 is Dr. Miller's, 5 and 6 are concerned, there is no, so far this aspect is concerned, teeth. Because now the question is whether this teeth, Miller, whether it is a sharp cutting is and this, whether this injury is by the teeth. So these two aspects, Miller, that has to be considered by your LRC.
No, if you bite,
Yes.
teeth will not come out.
Yes.
Then
And,
what will miss?
suppose so Bhangi Jaichi will call him, that also, that part is also not that recovery of that is also I have not
no
also,
recovery of
yes,
that teeth.
subject to correction, but that part is there.
It sounds bit
Yes. So Lordship, what I have relied, my lords, your Lordship has to, I am giving,
Yes.
I have also got two judgments. Because that. Lacerated part is hard and blunt. There is opinion is second is previous. But this trial court and appellate court, my lords, so far this aspect is concerned, they have adopted your Lordship, my lords. Whether the bite injury, question arises before Lordship, whether the bite injury is caused by appellant could be classified as grievous or that your Lordship. And I have also substantiated with your judgments.
This judgment says what?
Yes,
That cannot be caused the breaking of the teeth.
Sankar Lal.
No, Sankar Lal also, my lord, Sankar Lal that 2006, that also says, my lord, that is simple.
Which
Sankar Lal.
Which para?
Sankar Lal. Not exact that I have from the online notes that right. I have been para 8 is there, my lords, but I have also that another of Manupatra that they say it's that I will be Manupatra because that is there.
No, Shankar Lal, which paragraph you are relying?
I'm coming, not that thing. That. Okay, para 8, I say, my lord, that it's already different from PW2 inverse that I rely, my lord, this in the cross examination admitted he had not seen, but injury Gupti he had admitted when he read spot all the three accused, but admitted he has seen Gupti in the hands of some. He had not seen appellant, supplementary factor in this, further he had not seen asserting, he had also seen that's simple. I am providing in course of the day that I have, in fact, that exact wording I have a copy.
What?
So whether it is grievous or simple, as
No, see, if the expert witness comes to the witness box, they said it is grievous.
Yes.
The court can't substitute his
Yes.
opinion.
Yes.
Opinion. The only doubt which is being created is the doctor in the same time he says that this may cause out of fall. And it sounds so improbable because biting in the lip and the tooth will not come out.
Yes, my lord.
Tooth will not come out. So therefore that there is a doubt there. There is a doubt insofar as grievous hurt is concerned. But if that doubt is also he has taken in a right spirit, but how will you get over the 323? It can't be a case of acquittal. The injured witness has said you could not elucidate anything from the injured witness in the cross examination. He stood firm. And the testimony of the injured witness is corroborated with the testimony of the doctor, if not anything.
Yes.
Doctors. How will you get over that?
So far as
If you are seeking for a acquittal. If you are seeking for an acquittal, how will you are trying hard to show that no, it is not a grievous hurt over. There is a doctor's evidence. I can't substitute the opinion of a doctor. He is expert witness. If the doctor says grievous, it is grievous. I can't say that no, it's not grievous, it is simple.
Yes, ma'am.
Who am I to say that? You can very well say the cause of the injury might not have been caused by the accused. It might have been caused for XYZ reason. But you can't say that, no, argument may be that the grievous injury is not caused by me.
Due to fall.
Grievous injury is not caused by me.
Yes, that is.
But the doctor only says it might have caused fall. Where have you suggested or anything to the witness that he fall or anything of that sort? Nothing. You have cross-examined anywhere, have you said anything?
And so far the 2004-10 SEC Lordship is concerned, para 2, the Lordship kindly see that from that Shakil Ahmad case.
Shakil Ahmad.
Hard line. What teeth of a human being, first page. Teeth of a human being cannot be considered as a deadly weapon, that one of I marked.
Para
2 Lordship.
Yes. Apparent sense conviction.
Yes.
Shakil Ahmad.
Fourth line. Teeth of a human being. Lordship kindly have a look at. Yes.
Human being cannot be considered as the deadly weapon. As per the description of hardly weapon enumerated in section 326, hence cannot be excluded. It remains
So,
to
yes. So far your Lordship is
325.
concerned, 323 is concerned, he has to.
And you are convicted for 325 only.
So in that way.
326 is not made out because
Yes.
grievous hurt caused by a weapon.
Yes.
Teeth is not a weapon, so 326 is drop and 325.
He has to that satisfy on that.
Alter the conviction to 325.
That's that.
So then how will you undergone? Tell me how much you have undergone.
They surrendered. He surrendered on 30th of January 2001 and released on bail on the same day. And thereafter he arrested after the disposal of the appeal. Arrested on 31st of May 2011 and released on bail by the Honorable Court on 5th of August 2011.
3 months you have already done. That's what it says. The sentence is 6 months.
6 months and 1 year. 6 months for 324 or 1 year for 324?
6 months, 324. 1 year, 5 months. 2 months.
Incident is which year?
2000.
Yes, Mr. Rahul, what do you say?
FIR on 17th December 2000.
Yes, Mr. Rahul.
My lord, it is purely that order has reflected the PW5
I am
document.
not interfering in the conviction.
Yes, my
Sentence.
sentence, my lord, 324, my lord, 6 months. And 1 year arrive for the
1 year substandard sentence is 1 year.
My
He has
lord,
already undergone about 3 months.
3 months, my lord. 3 months already has been passed, my lord. 7 months now.
What was the age?
Age, now it's your age is
32 is
60.
the year. Because it is acid.
60.
2011, he was 40 years. 2011.
53. 53.
They were friends.
They all four.
Four
of them were
all are
friends.
friends. It is stated in the FIR.
You
Not friends. They
You
were sitting
yeah.
together.
There were few of them. Custody, you give date of custody. Like here. Right.
What is acid?
Since nobody appeared for the petitioner on various dates, when the matter was taken up on 18/6/2024, Mr. Satyabhat Hanti one was appointed as a McCabe. When the matter was taken up for hearing today, Mr. Das appeared for the petitioner. Therefore, Mr. Das, filed with Mr. Satyavart, 1P1, reviewed the matter.
His date of birth is 1973.
Tell me the date or age. Yes, 51 reviewed the matter. I record appreciation for the effective assistance rendered by the amicus curiae in this matter, for the assistance he rendered, and the is entitled for the honorary. Give the dates.
No. In fact, one submission, while your lordship is appointing anyone as amicus curiae, actually kindly direct the registry to bring the name, my lord. That is not coming. Probably my
In the
lord
cause
says
list.
in the cause list.
Because this way is not coming that.
So, my lord, it's difficult to know the date and for
that-
others also, the
That's why
difficulty.
I could not.
And this time, today's your name has been reflected?
No.
No,
I will-
no, it's not that.
In any of the matters, where my lordship is
Amjan
appointing.
Give a.
Because that is.
Earlier that has not come, my lord. It is now regularly coming, my lord,
Regularly.
since last week.
In my case, Mr. Mahanti's name has not been reflected.
Thank you very much for.
Grateful.
Then 30. That, my lord, amicus curiae, Mr. Vishwal is engaged. He's in another
You're
court.
supposed to come, okay.
Or
We'll-
whenever he
we
come.
will- We'll keep it, any other matter who is ready,
Yes.
Weekly, my lord. Weekly.
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 Okay, come to the weekly.
Weekly. Yesterday, my lord, that has been passed over.
What about?
And they also mentioned that 29.
Huh? Take it out.
The board. Last week.
20?
29. उन्होंने weekly कर ले.
Nice, nobody is there. 20 weekly, 29.
He has mentioned yesterday, my lord. Taken up.
What is this matrix about? Charge, conviction.
29 my lord थे. 76. Sentence 7 years and fine 5,000.
Nobody is there. Chalo, आगे.
49. हाँ.
Yes. Not there, huh?
89.
Why you are,
Yesterday mentioned to taken out today.
nobody is there. Hmm?
49.
You are mentioning and evaporating. 59. Okay. Yes.
Sorry, my lord. Yeah, one passover, my lord. Wrong file has been entered. It was okay, sir. One passover, my lord. File has been misplaced in that.
You mentioned yesterday, today you are not
Sorry,
there.
just 1 minute.
चलो अब आगे तक
89.
89 हाँ कम 89 yes
My lord. The petitioner convicted under section 457(380). Allegation is on the alleged date of occurrence, the petitioner entering into the house of the informant committed theft of utensil, cloth, rice, cash. He was convicted under section.
in that 138 matter where you are appearing is there you mentioned it item 13 na
Yes, my lord.
item 13 I fixed it on 11th I have indicated that no assignment. No adjournment will be given. He is for opposite party. Yes.
And sentenced to undergo RI for 2 years. Appeal was dismissed. Here, my lord, kindly have a glance to running page 10.
10.
My lord.
Yes.
The then from the bottom, 10th line. PW 1 is the informant, PW 2 and 3 are the seizure witness, PW 4 is the judicial magistrate who identified the TI parent to the stolen article. And PW 5 is the investigating officer. PW 2 and 3 are the seizure witness. The evidence of PW 2 and 3 transfer that they have not.
You are reading from where?
Page 10, my lord.
Judgment.
Page 10. Internal page 3, running page 10. From the bottom 10th line, the evidence of PW 2 and 3 transfer that they have not seen when accused person brought M1 1 to 3 from their house and produced before the IO, but they have seen the seizure of article by PW 5, and PW 5 told that it was seized from the house of the accused person. So PW 2 and 3, they have not seen when the accused person gave recovery of the stolen article from his house. Only PW 5 stated that the accused person has given recovery of this.
PW 5 is the magistrate.
PW 5 is the police.
PW 4 is the magistrate.
4 is the
Magistrate, he is the witness, he conducted the PI period of the stolen article.
Okay.
Not accused person of the stolen article. This was the discrepancy.
Seizure is doubtful.
Mine.
That particular.
Mine.
Yes.
And seized item is 2 sari and 1 lota.
That's the only case.
Mine.
That is the, but it is the material subject was identified by the magistrate in the
But
TI.
identified by magistrate, but it has been taken out from his house. What is the
That has not been seen by no one has seen the occurrence, and it also not seen by the PW 2 and 3.
conviction is on the basis of what?
Confession of own confession before police.
Well, the police has arrested, and subsequently that article was
confessed.
recovered. It was recovered from the petitioner's that accused house.
House and the recovery is doubtful.
And his only submission is that the recovery is doubtful.
You
But
say
the
it is 27.
No, no,
not
not
right.
27.
Then
No, no.
What,
No,
what,
27.
That is-
what exactly is your case there?
Case is on suspicion, police arrested the accused person.
Take confession from you.
Take
and-
confession
and
from my house.
alleged to have recovered, which is doubtful.
My lord.
and it is identified, my lord. That stolen article was
Identified
identified.
is subsequent thing.
My lord.
Maybe identified, but whether the same articles were recovered from his possession or not, how do you prove it?
My lord, that is on doubt. That is
How the
accurate.
trial court deals with it?
My trial court, my lord, PW, that
Trial
page 10, my lord, that PW 2, first para, my lord. PW 2 and 3 have also not seen the same. The only evidence against the accused person says that the accused persons on suspicion.
Page
Page 10, my lord, that internal page 3, my lord. First line, my lord.
yes.
PW 2 and 3 also had not seen the same. The only evidence against the accused
You are reading
person,
where? PW cross examination
my lord, first
at the top. Asha.
at the top, my lord,
PW 2 and 3
had not seen the same. The only evidence against the accused persons is that the accused persons on suspicion were arrested by PW 5, and while they were in police custody, they admitted they are guilty and led the police to their house and gave recovery of the stolen articles. And then, my lord, page 11, my lord, internal page 4. Last, my lord, top from top, last 3, from the top, line 3, my lord. The
Where?
evidence of PW 4.
Next page.
My lord, from the beginning, 3 lines, my lord.
Which page?
Page 11, my lord, internal page 4. The evidence of PW 4 reflects that on the requisition of police, he had conducted TI parade of MOs as per the provision, and PW 1, 2, and 3 identified the suspect articles correctly. PW 1 stated that the MOs 1 to 3 belongs to his family, The learned counsel for the accused person could not establish any evidence to disbelieve the same.
Now, 1, 2, 3, who are they?
One is the my lord informant.
Informant. They might have identified. This is
They
not a
identified.
dispute.
My lord.
That these are
Only
the
dispute
articles.
that whether it was recovered from the
From
accused
him or
person.
not, you are drawing corroboration from their disclosure only.
Yes. And my lord, on the same page, my lord, last page 11, my lord, same page, last 6th line, my lord. The evidence of PW.
When the stolen articles were recovered from the possession of any of the person, soon after the commitment of theft, under section
That is not
114A of
114A.
Evidence Act, the court will presume that the same person from whose custody
My-
the articles were recovered may be the thief and may be received the stolen articles. Recovered, that is the important thing is whose custody it is recovered.
My lord. My lord, that
Presume
para,
that the person whose
last 6th
custody
line,
the articles are recovered. Recovery has to be proved. Then the presumption on 114 will operate.
Yes.
My-
But recovery is not proved.
Yes. And my lord, last 6th line from that page 11, my lord. The evidence of PW 2, 3, and 5 transpired that these articles were recovered from the possession of the accused persons, and soon after they are. So the court will presume that the
That is
accused
what I am saying.
persons,
So who is two?
Who is the seizure
2, 3 are suitor witness, my lord.
Then this finding may be wrong.
Two,
Evidence of
three-
PW2,
2, 3, and 5. 5 is the
transpired
I.
that, these articles were recovered from the possession of
Possession of the person.
come to the 2 and 3 seizure.
2 and 3.
Come to the 2 and 3. Come to 2. Evidence of 2.
I know the accused person about 6 to 7 months back. The occurrence took place. I and Basanta had been to Jhadabandha,
At which
as who is returning in the motorcycle in the morning at Kotola near Panasahi. The Thana have stopped me. Police seized one dhala and one cloth from the house of Gatia Pradhan and approached
and prepared
the seizure list.
seizure list.
By the exhibit 2, he also seized one sari from the house of some Pradhan and prepared the seizure list. Exhibit 3, exhibit 2 by 1, 3 by 1 are my signature. MO1 is the said dhala.
Come to cross examination.
I have been to Jhadabandha. My times.
I saw the police near the.
I was returning from to my house at 6 a.m. I saw the police near the Panasahi. About 20 to 30 people gathered
near
the house of accused person. They are local people. Prior to my arrival, those people were present there. I do not know the people. I had no acquaintance with the accused. My house is at a distance of 10 to 12 kilometers. Kodola, Thana Babu called the local people, but they did not come forward to be the witness. On my arrival, I saw that Constable holding the article. Before his arrival, Constable was holding the article MO1 and 2, 3. No seizure list was No, schedule list was arrival, last word, arrival, say what padi.
Where is that sentence where it says that I have not seen the seizure? At the next para 5.
At the spot near the house. My house has a
Your entire case is on these two witnesses. You have to read it out. I'm struggling. You should have been ready with every line of it.
From the
Where
type.
this finding appears to be wrong. Trial court finding.
Yes.
He has said that he was in the spot when the seizure was taken.
Only it is readable. I saw that constable was holding the article. That means before arrival of the petitioner, the constable was holding the article. MO 1 to 3. Para 4.
Para 5, what is this?
Para 4. Para 4, I saw that constable was holding the article MO 1 to 3.
I saw that the constable was holding the article 1, 2, 3.
No
Thereafter,
seizure,
no.
no seizure list was prepared before my arrival.
Next, at
At the spot near the house of the accused, the exhibit 2 and 3 was written. I signed the
2 pages.
Two papers.
Two papers. I had not
seen.
Gone through the.
I had not seen.
I have not gone through the exhibit 2 and 3, but it was read over as to me.
And explain to me.
Explain to me. Now due to I cannot.
Level of time. Lack of time. I cannot. I cannot speak in which paper that was written. I cannot speak in which paper that was written. Now I cannot see which paper was written first and which was second.
Do you have anything typed?
No, my lord, only this copy he has supplied yesterday, but there is no.
In the judgment, my lord.
Judgment, see, we are testing the legality and perversity of the judgment.
My lord.
The findings may be wrong. We have to see the evidence.
My lord, that is.
You have to read the entire evidence. Then how the two court last line two court. Thana Babu identified the house of the accused persons
to me.
He has no idea which is accused person's house also. Yes, next PW 5.
PW
3. Read PW.
I know the accused person about 6 to 7 months back. The occurrence took place, which I and PW2 were coming through Kodala in a motorcycle. Balimi Thana Abu called for the spot on my arrival.
If you are aiming at an acquittal, then you have to do some homework.
Type kariyo. Type
We can't try and keep on reading here. If you are aiming at an acquittal.
My lord, I am passing the matter.
If you think that it's a case of acquittal, yes, you have this point.
Yes.
This one point can lead you to acquittal.
My lord. And next week I will please
Type copy you give, then only it can. Otherwise
It
it
may
can
be,
be-
yes, my lord, but the finding of the court, my lord, that is presumption was taken.
So see, the first page 10 finding and page 11 findings are contradictory. Page 10 it says that they have not said anything.
My lord.
See, page 10 says PW2 had not seen the same.
Yes.
Whereas in page 11, the court says that yes, they have proved this is yes.
Before
So
that,
therefore, I wanted to read this the entire evidence.
Yes.
and my lord, before that,
If page 11 finding was would not have been there, we would have proceeded with the presumption that it is not proved. But he is giving contradictory finding. So therefore, you have to read it and find out which is the right finding.
Kindly when next week I will give a type.
And counsel for the petitioner seeks time to place on record the type copy of evidences of PW. Yes.
my lord, he may be directed to supply that
Yes,
copy.
definitely.
156.
No, he is which one is from?
30. 30 as well. 30.
Yes. Then easy file.
Highlight करा पड़ा नहीं
You have file.
File रखी को ले जी.
Sometime when you are there, file is not there. When file is there, you are not there.
File तो रखी को पूरा file तक नहीं गया.
ये नहीं तो
सर
missing
let it pass over.
नहीं missing नहीं है चलो.
हाँ KBC में
देख लो.
Immediately who was there, just see.
हाँ देख लो.
Yes.
126.
Hmm?
126.
I included with
36, 26.
126.
Oh, 92. चलो. अच्छा एक. Yes, madam. Convicted.
Convicted of section 5(2) read with 5(1)(d) of the Prevention of Corruption Act. And sentencing to undergo variety for a period of 1 year and offense under section 161 of IPC and undergo variety for a period of 2 years. To fine of rupees 500. The Substitution case is there on 25/10/1986. The complainant lodged a written report before the SP Vigilance Hon'Ble, alleging there is that the complainant was working.
The appellant is alive.
Yes, my lord.
Yes.
Because in 1992 he was 50 years.
Yes, my lord. I have received the
Yes.
instruction on 27/6/2024. He is alive.
Okay. Yes. Yes. The file-
Complainant was working under Govinda Ram Modi and also he was delegated a power of attorney in favor of the complainant for appearance of the official work. Govinda Ram Modi filed the urgent certified copy of before the Tahsildar Panpost for supplying of a certified copies of a relevant quota and the enforcement case of.
Hello. Table. Yes. Yes.
The complainant.
Use the mic.
Govinda.
Use the mic. Use the mic.
Complainant working under
You
Govinda.
highlight the point and
Let's-
you can't keep on reading
Yeah,
FIR and all. Eh?
There are 8 Eight witnesses are examined, prosecution examined.
Yes.
And the PW1 is the police officer who gave a demonstration regarding change the color of the solution. PW2 is the overhearing witness. PW3 is the clerk of Kumaramunda Tahsil. The appellant was working under the Tahsil. The PW4 is the applied the certified copy. PW5 is the complainant decoy. PW6 is the sanctioning authority. PW7 is stated magistrate witnesses.
Come to page 17.
Page 17.
17. Come to state of a demand. Para 7.
Page 56, madam.
Paper book.
Paper book, page
Para.
17, the judgment.
Right down. Reading. Regarding the demand of bribe, the evidence of PW4 and 5.
Regarding the demand for bribes, the evidence of PW4 and 5 are relevant to PW5 stated that he was the power of attorney of his master Govindaram Modi and was lodging after the official work of his master. He says that his master applied on 17/10/1985 for certified copies of the order sheet and potta, etc. in the lease case, and on the instruction of his master, he went to the Tahsil office on 2010/1985 and approached the accused for the certified copies. PW5 says that the accused told him that the certified copies were ready, but he could deliver those copies only after a sum of ₹2,000 is paid to him. PW5 then says that he contacted his master PW4 and told him about the demand, and then both come to the accused who again told that unless ₹2,000 is paid as bribe to him, the copies could not be delivered. Then he and the PW4 contact the accused on 24/10/85 and told that money could be paid.
So
on
demand
20
is according to prosecution proved through 4 and 5.
Yes, madam.
Isn't it?
5.
4 and 5.
PW5 is the
5 is the requirement.
PW5 is the complainant.
Yes.
The PW4 is the apply the certified copy.
He's the master of
He is the
PW.
master, he is the employer.
And the demand is ₹2,000. That is
Yes.
confirmed by both of them. Yes.
Yes.
Next.
PW5.
And PW4. Next paragraph.
The evidence of the PW5 person. Please. PW5 page 50, running page
51. 51.
51, running page 58.
Are you doubting his evidence? PW5.
Cross-examination.
50?
58, running page 58.
Yes.
Cross-examination. Paragraph 6. Sri Govinda Rana Modi, my master had iron business. He used plea of the accused.
Used to purchase land
Yes.
and sell them.
He used to purchase the land and sell the same. Modi Babu told me on 20/10/85 for the first time that he had applied for certified copies at Tahsil Office Panpost on 17/10/85. I cannot specify the details of a lease case in which Sri Modi applied for certified copies. By the time I was examined by the IO, I did not know the number and other particulars of the lease case. I cannot say if actually Sri Modi had applied for certified copies on 17/10/85. I born and brought up at Raulkela. My father was RI of Bonai Tahsil. He has retired from government service on 31/7/90. I remain separate from my father. My father now.
Yeah, what do you want to say?
Lordship, the next I stated a vigilance case, the stock witness of the complainant is the stock witness, vigilance department. I stated last, that I stated vigilance case against industry officer besides the present case, I was a complaint in another vigilance case against the officer of OSFC. I was a witness in another vigilance case of Bonai. I was paid salary of ₹500 per month by Sri Modi.
He was
That has not
he was the complainant in other two cases. So therefore you say that he's a stock witness.
stock witness of the
Right.
vigilance department.
Yes. That effort
Another is the power of attorney has not been exhibited and not only hearsay evidence.
These are the two things.
That's it.
Insofar as 5 is concerned.
5 is concerned.
Yes. Acceptance, sir. Acceptance finding.
Page
The
21.
Yes.
Page 21 is the findings of the court bill
Yes. Ready.
regarding acceptance. Starts from page 20, para 9.
Acceptance. Yes. What was your defense?
No, see,
What was your defense?
defense please the appellant, he wants defense please uh, the appellant is stated that the complainant give the 2,000 rupees for a supply of iron and iron rod and cement. The business of the master.
No, you are a government employee.
Yes.
Why have you accepted this 2,000?
The construction of the house, the plea of the defense is that in the case record, the appellant construction the house and received the cement and iron rod. The articles for construction.
You are constructing the house.
Yes.
Who you are supposed to pay or they will be supposed to pay?
The appellant supposed to the
Why
construction house.
why they have paid to you 2,000?
Only for concession by ତାକୁ ଦେଇଥିଲା 2,000 ଟଙ୍କା ଯେ ତା ଘର ତିଆରି ବେଳକୁ ସେ ଆଣିବା ପାଇଁ କି rod business se karuthile. That is the plea of the
defense plea has miserably failed.
Of the
In fact,
unusual story.
Yes, and DW1 they have roped in DW1 and 3. 3 has miserably failed to prove this aspect.
313.
Huge contradictions are there.
313.
Detection took place in the premises of the employer. Detection was done there. He has accepted that bribe money. He has taken that certified copies over there to deliver. It is not that the detection has happened in the office. It has happened in a third place.
Why has he gone there?
Well, to accept the bribe money and to give the certified copy. This was the deal.
That has not been, the PW2 is the overhearing witnesses. The overhearing witness has already been hostile.
But that certified copy has been seized from the detection spot. That detection spot happens to be the premises of the employer. This appellant went there with these certified copies to deliver and accept the money. So demand, accept and recovery, all 3 aspects have been proved. Thereafter, the defense plea that has been taken, that has miserably failed because DW3 has given all contradictory statements against the appellant.
Demand is not the complainant is not the.
Exhibit 6 happens to be the certified copy.
Here, please dealt with that, page 23, come. The plea of accused.
Yes,
is there.
Defense plea.
Is given.
Para 11, page 23.
Let's see. DW3 to prove the payment of advance.
Yes.
He said that on the date of payment of advance, he had only 1500s with him, and so he borrowed the 500s from the DW3 and paid 2000 to PW5. DW3 said that one day the accused come with another person on a scooter and told him that he has purchased something for from 2000 but running short of a fire. That is the plea of the.
Thereafter,
defense.
the depositions have been taken care of. The accused as DW2. Thereafter, the anomalies have crept in.
DW.
Thereafter, the anomalies have crept in regarding the evidence of DW2. He said he has borrowed the money to pay advance to PW5, but DW3 says that the accused has already purchased something. And to make payment
Already
for the
purchased something.
Yes, he says he was about to purchase. He says he has already purchased. The second contradiction is regarding the year. While accused says that he borrowed this money in 1985, DW3 says that this money was borrowed in 1986. Major contradictions. Thereafter, the accused DW2 said that he used to record all the expenditure and purchases regarding this construction in a book of account. But he has not mentioned about the payment of 2000 to PW5 in this book of account, and has also not mentioned in
How
that.
the appellate court has dealt with? It is appeal, huh?
One
criminal.
One special.
Special.
Yes, madam.
PW5 is only my commission. Let's see.
You have a very difficult case.
Yes.
PW5, the complainant, his work is not pending the complaint.
What is the sentence? What is the sentence about it?
Sentence 1.
That's
2 years and 500 rupees.
2 years.
No.
Okay. 5 1D and 5
5-2 months.
5-2.
1 year and a fine of rupees 500.
I can't give pure benefit also. That's the problem. In PC,
This is the old act. This is the new.
Old act.
Xerox copy. 47 act. No, this is the new act. Your lordships are looking.
47.
It's no after Xerox.
Old act.
What is the maximum sentence you just see?
7 years.
Huh?
7 years. Maximum.
Minimum? Prescribed.
Minimum.
Just check it up and tell me.
Shall not be less than 1 year, but which may extend to 7 years. And
1 year,
fine.
1 year sentence is rewarded.
Yes, already
can't be.
minimum sentence have been given.
There's anything? The trial
Only
court
the-
has very carefully dealt with
Yes,
all these things.
analyzed in great detail, all the evidences. Very rare to see.
Yeah. Anything?
PW5, the work is not pending before the appellant. PW5 said that the power, his master give a power attorney. That is that has not been proved.
Do you have any judgment? So far, what you have argued, the only point which is very
Only
clearly
one point.
illuminating from the record is he is a stock witness.
He just talk witness and.
Do you have any judgment? Saying that if he is a stock witness, his testimony has to be thrown out.
Yes.
Do you have any judgment?
May I some tomorrow, Lordship, judgment.
No, I am reserving judgment.
In the meantime.
That is the only thing
Only.
which you could prove from record. Because he is the complainant in 2 more cases. So you are rightly saying that he is a stock witness.
Stock witness.
You
And
show
another-
me any judgment where Supreme Court or any High Court says, once it is established on record that somebody is a stock witness, the evidence has to be discarded. Completely discarded. Otherwise, the evidence is there. The other witnesses are there. 4 is lending support to 5.
Yes, ma'am. Corroboration is there.
Corroboration is there. So therefore, that difficulty is there with you. If 5 is taken out from the record, then you may have a case. For taking out 5's evidence from record, the only thing is if you can get some statutory provision or some judgment which says that if he is a stock witness, then his testimony should be thrown
Discarded.
in the dustbin.
It's totally discarded.
That totally
Totally.
thrown in the dustbin.
Yes.
If you get that, then I think you have a case. Otherwise, you don't. I heard we and Mr. Ridley at length. Judgment is reserved, and we should be paid for a 1-day time to file supported judgment. You may supply the copy of the supporting judgment by tomorrow. By tomorrow. Day after tomorrow, judgment.
Now let's see. Hearing concluded, judgment reserved.
Hearing concluded.
Judgment.
ये इसके साथ
Amicus curiae.
You are amicus curiae.
Yes.
Okay. Oh, no, amicus curiae ना. ताले 5,000 for this. I record application for the effective assistance rendered by Mr. Bay, and for which a honorary of 5,000 rupees to be paid to. You got a file?
Yes, sir, my clerk has checked me. He thought that I am not here for the on to DRT.
Generally, what happens is if you keep the file like this,
Yes, sir.
somebody will argue
There
put
is
the
no
file
name.
at the top and take
No,
it.
no, I am not writing my name on your. Here is the case.
3030.
30. Sierra Larrabee number 1122 of 2014. Conviction under section 376 506 IPC for 7 years, for 376 and 20,000 fine, and for 506 there is a 6-month conviction and 6 months and 5,000 fine.
Yeah.
Both the sentence will run concurrently. Here I am taking the fact of the case manner. The affair was, the incident took place on 13, as per the affair, incident took place on 13/9/2004.
Yes.
And the affair was filed on 19/9/2004. In the affair, it has been stated that may I read the entire affair or fact only?
So what you tell me, what is the case? And is a case of acquittal?
Yes, yes, ma'am.
Oh, so
It is a consent.
What are the grounds
Yes,
of
madam.
acquittal? If it is acquittal?
Yes.
Yes.
Your Lordship may kindly see the
report of the doctor, my lord. Page 75 of the
Doctor.
LCR.
Yes. PW.
Doctor is PW. One
11.
11.
And 14 exam the accused.
Huh.
11 exam the.
11.
11. Yes. Very nice.
Yes.
I know the accused person. I know nothing about the case. Finish. No cross examination, nothing. This is his statement.
There is nothing to cross-examine here. Because she has
Doctor says I have nothing. This is one line. Examination chief.
That is one, but she has been examined on the.
Only
After 5 months.
no.
So just not just matter the.
4 दिन ପରେ ସେ FIR ଦେଇଛି ପରା 5 दिन ପରେ.
After 5 days, matter that may
But
not
doctor
be.
says I have
Keମିତି?
nothing to say.
Matter the doctor stated that.
I am reading, my
I
lord.
know the accused person.
No, my lord.
No,
Second paragraph.
I know nothing about the case.
Yes.
Decline.
No.
11.
11. PW 11. That is error.
11 only I am reading.
Doctor, my
Doctor PW 11, my lord.
Prashant Kumar da.
No.
PW 11.
11, my lord.
PW 11.
और किसी का आ गया क्या ये?
नहीं, olga केस को उठाई थी.
This is 31 ना?
30 sir.
30.
30. 1122. Supplementary दियो. Supplementary दियो. से weekly.
Oh, weekly.
कहाँ कांडू? यही ना? ये कहाँ?
से बुझी पर ना तो weekly चलता है supplementary पड़ा ला.
30.
That's what I'm wondering. He says weekly something I know nothing about the case. Yeah.
My lord.
1 minute.
On 29 2004 I was
1 minute.
हाँ.
ये
Yes.
Rudananda Tandi.
No. Doctor.
Party name?
हाँ.
Yes, sir.
Party name Rudananda Tandi.
Rudananda.
Yes.
Huh?
Yes.
Rudananda Tandi.
Yes.
Rudananda Tandi.
PW 11.
Yes. PW.
Got
11. PW 11. Yes.
My lord. On 29 2004 I was orthopedic and gynae specialist Junagadh Hospital. On that date, on police requisition as per order of medical officer in charge, I examined victim Malabag, son of daughter of Sakul Bag of village Makhala and found as follows. This examination has been made after 5 days of the occurrence as per the FIR. Occurrence took place on 13/9, FIR was lodged on 19/9, and she was examined on
20th.
Now, the age has been stated.
Incident happened on
13/9.
13, FIR 15,
FIR 19.
and examination 20.
20th. My lord.
No,
And
no
age of the victim is 18 plus or 19.
No bodily.
No bodily injury was noticed on the part and parcel of the victim. No physical clue of sexual intercourse was noticed on her cloth.
That was amended when
7 years.
And on the other
Yes,
day,
there was a
but the
proviso.
judgment is reserved by your lordship, my lord. Mr. Dhal arguing.
Yes, I have already, that judgment is already there, but there was a
They are, my lord, you have
proviso to 376.
reduce the sentence, my lord, since that is coming under the old
Whether
act,
that
my lord.
proviso could be employed in this case.
ମୁଁ ଦେଖିଲି
ଦେଖ ପୁରୁଣା old
CRPC.
Old. On the other day, copy detailed name.
that proviso says by reasons you can reduce by assigning reasons.
Assign reasons.
Court appreciation.
Reasons. That is, there are also some decisions of honorable appellate court. Cannot be reduced. If reduced, the reason
Reasons has
must
to be.
assigned by the any revision. The acquittal in a revision, my lord, that is less chance than confirming judgment of two courts.
Maybe if your lordship to go through the averments made in the appeal as well as the trial court judgment, paragraph 9, 10, 11, everywhere there is a contradiction of the evidences. It has been recorded.
Contradiction.
No, not minor contradiction, my lord.
Yes, like that, my lord. That cannot be taken into consideration, my lord.
Minor contradictions are.
You just assist me in that way, whether a sentence can be reduced in special circumstances.
I will tomorrow, your lordship keep it reserved, I will give.
Your lordship already delivered, and I don't know, my lord, that case.
No,
my lord.
that I have given dictation,
You
but in
deal to the matter.
fact of this case tomorrow, part head tomorrow.
Your lordship keep judgment reserved, I will only give that person only.
It's a dhal manner given.
That must be there with me, but he let him do it.
I can discuss.
Issue लगा देना करते हैं.
Your lordship keep the judgment reserved, I will give it tomorrow. That provides a person I have to give, madam.
हाँ नहीं sentence regarding the sentence you.
Yes. I will give that. I will give that one.
Can reduce, my lord. Sentence can be reduced by the court while dealing in this matter. But the court thinks.
But after amendment I can't do.
Give the reason, my lord.
After amendment I can't do because that provision is taken. Whether that provision is applicable in this case.
Yes, 2004 I will see.
Heard Mr.
ମୁଁ ଦେଇଦେବି ମୁଁ ଆଜି ଖୋଜି ପାରିଲିନି ଗୋଟିଏ
A.K. Biswal Lerene Makeshwari Makeshwari for petitioner Mr. Ragada so judgment trigger. I record appreciation on record regarding the effective assistance rendered by Mr. Vishwal as an Makeshwari in the present matter. Since you are declining to accept and Mr. Good grace, Mr. Vishwal has submitted that he is not willing to accept the honor offered by the court for the assistance he has rendered. The court record appreciation for the same as well. This matter, judgment is reserved. Mr. Vishwal would be filing the judgment
and relevant
quantum of sentence.
Within 1 day I will file. Oblige.
क्रिमिनल अपील ही 4 जजमेंट रिजर्व हो चुके
The revision and one appeal. I think we should stop here. I have
yes, my lord. Otherwise it gets on piling up. Yes,
unnecessary piling up.
Yes.
I'm trying to finish up the
Yes,
thing also remains.
yes. Hardly any time left also. Let's.
I have to mention item 177.
That is there in the weekly list, my lord. That will be taken up.
Waiting from the
Tomorrow, you want to argue?
Only one side of stated the falsely implicated appellant.
That's right. Agree. But are you interested to argue the matter? Tomorrow 2 o'clock you come. Is it revision or appeal?
It's an appeal, my lords. It's appeal, my lords. It will take some time. Let it come 2 weeks after, my lords.
Which year appeal? Appeal of which year?
14, my lords.
14.
Yes, my lord.
We are struggling to
90s.
92 appeal.
Both sides are over, but both the sides are over, but this side and that side both.
But he has to ready also. Old appeals are there, they are getting ready. Not that they are also overloaded. And the court is also overloaded.
Both the sides are overloaded, my lords.
It is there, I'll take it up.
Grateful.